Oblige your lord. My lord, another item number 43, my lord, with the content of the other side, my lord. It may come up after vacation, my lord, due vacation.
43.
With the consent of the other side.
So you're for the appellant.
Appellant.
I want 43, with the consent of the other side. After due vacation.
My lord, may fix a date, my lord. Any date after due.
Hearing day give us any hearing day.
On 11th February.
11th of February.
Oblige your lord.
May it please your lordship. Lordship, I beg to mention for listing of a matter motion on Thursday, lordship.
What kind of matter?
Lordship, criminal petition, if possible.
You make a mention before court number 11. Court number 11.
Oblige.
Lordship, may I please your lordship? I beg to mention listing a regular bail application, lordship. That bail application was earlier rejected by the honorable court on 19th. Lordship.
Prior vacation you want. Before vacation you want. We don't have any space. Today also see most today. Lots of matters will be left over only today.
19th, lordship. 19th, lordship. On 19th, lordship.
No, whatever, 19 or 20 GM.
I filed it on yesterday.
3-1. 3rd of January, because we don't have any. Yes, I mean, you now see today is also 53, 54 matters.
Motion, paying for a motion, lordship. This thing of motion, lordship. Before vacation, lordship. 19th, lordship.
Okay.
I beg to mention for listing on motion matter, anticipatory bail, filing
3rd of January. 3rd of January.
3rd
3rd of January, only reopening day only. 3-1.
Millet petitioner unnecessary dragged in the case, without
3-1.
any
Okay,
offense.
we are 3-1. We are here in matter. 3-1.
Please, my lords. My lords, item number 20 of the daily list. My lords was pleased to fix the matter today due to the urgency of the matter because the accused has been incarcerated for 2 years, 2 months as on today. My lord was on the last occasion pleased to appoint an amicus. However, there is some difficulty on her part today, so she has requested me to mention it. She's all right on any
Difficulty
other
on the
day.
part of the amicus.
Yes, my lord. She's all right on any other day before the vacation, my lord. I pray considering the
Before
urgency.
vacation?
Yes, my lord.
Only
There's a
possible.
grave urgency, my lord. Kindly any
Not
day before
possible.
the vacation. My lord,
Not possible. Why don't you understand? It's not possible. Today also at least 20 matters will be left over today also. We don't have
please,
it.
my lord, on the 3rd then, my lord, I pray.
3rd.
I'm obliged.
May I please your lordship? My lord, I beg to mention item number 37, my lord. My lord, I have verified the official of my
Which number to position? Hello. 2020. Item number 20. 3-1.
item number 37, my lord.
37.
Yes, my lord. As per the official, my lord, neither service is complete, my lord, nor my lord LCR has been received, my lord. Maybe
You want to await the service
service is
or respond number 2?
respondent number, but there are as many as 10 respondents, my lord.
10 respondents.
Yes, my lord.
All are awaited.
All are awaited, my lord. Official I have finished, my lord. After view vacation, my lord. Reminder may also be given for LCR, my lord.
Criminal petition 37 to Liquidia. From from record, it is seen that neither the LCR nor the services nor the notice is served on the respondents. Full stop. Await for service till next date of listing. Issue reminder to call for the LCR. Rest you will do the needful. List after vacation.
After view vacation, my lord.
It will come. Let's see.
May Lordship. I beg to mention for listing I on tomorrow for correction a case number. Order pass this honorable on tomorrow.
Today.
Tomorrow. Television.
May I please, Lordship? I beg to mention item number 14. As a conducting counsel, it's a AKS I have is not available due to some personal difficulty.
1-4.
Yes.
Who is the conducting counsel? It's not available today.
Matter may be taken after vacation. A date may be fixed on 7th of
After vacation, no. 7 is not possible.
around 8th of January.
I don't know. We have to see. After vacation, can it be before Bihu or after Bihu? After Bihu. After Bihu vacation without any date.
Much obliged.
Able Your Lordship, I beg to mention item number 13, 22, and 23 for adjournment.
1, 3,
13, 22, and 23 for adjournment.
that means 1, 3,
1, 3, 2, 2,
2, 2,
2, 3,
and
2, 3.
2, 3. 2, 2 and 2, 3 are the bail matters. You want the
Bail
date here?
After vacation.
These are all charge-sheeted one, I think, charge-sheeted matter.
Yes.
You are appearing for whom? Mr. Doctor
Eran Ahmed.
Ann Ahmed. Appearing for Ann Ahmed. Wait for adjournment. List immediately after vacation.
After vacation.
Immediately after vacation. On the request for immediately after vacation. Scan copy has also case record has already been received. Keep it. After vacation, please. Immediately after vacation, because it's a bail matter.
Lordship.
And
Yeah,
13 also same prayer.
Sir,
You are appearing for Ann Ahmed again.
Eran.
Your good name?
Islam.
Huh?
Islam.
Islam. There are 13 or 2 same order. After vacation. No need to write immediately after vacation. After vacation, this 22 and 23 immediately after vacation.
Lordship, I beg to mention item 31, Lordship. The
30.
Indian Council is out of station, so matter may be taken on Friday, Lordship.
CD is available.
Yes, I am of Friday.
Friday? No,
Yes.
not Friday. Friday we are not going to take it. Thursday, if it is possible on Thursday, otherwise not.
Okay, Lordship.
Thursday? Thursday is right? 19th. CD I have
Okay.
read of CDB retained till next date of listing, 1912 list on. And adjourn on the request made by the petitioner. Yes,
May I please, Your Lordship, I beg to mention criminal appeal, case number 341 of 2023. The matter is very urgent for listing.
you make a mention before the senior bench, court number 11, we will arrange it.
Much obliged. Lordship, I'd like to mention item number 11. Matter may be adjourned for the day, Lordship, and matter may be come up after vacation.
11, you are for the petitioner.
Yes, Lordship.
Add a request for petitioner after vacation.
Obliged.
May you please, Your Lordship, I beg to mention for listing of one criminal petition on Thursday. Urgency is that matter is fixed on 31/12/2024 in the trial court, and the petitioner has filed 2 applications to adduce.
Now see, listing of, because there's a senior benches there, so you make a mention before court number 11. They will arrange it. Senior bench. Court number 11.
Oh, bless.
May I please, Your Lordship, I beg to mention item 42. LCR not received, I think.
42.
Yes, Lordship. Kindly LCR be called for, Lordship.
42. NCR not received. Yeah, it is not received. I think
Also the case diary along with injury. Item
it is LCR or case diary.
Yes,
You
sir.
know,
Yes,
huh?
sir. Else, I was instructed LCR.
LCR.
services available.
It's a case diary or Miss Bora? It's case diary or LCR?
PD was called for.
CD.
Yes. That we have not received. It's a.
And respondent number 2 is also awaited, I think.
Services.
Services awaited for respondent number 2.
Yes, actually.
CD not received, issue reminder. Further, it is seen that the issue not CD not received, issue reminder. So the service is also awaited for respondent number 2. But you have taken steps for it? No, I think not this.
Have you taken steps?
Okay, okay, yes, yeah, they have taken steps. Service is still awaited for respondent number, is awaited for respondent number 2, list accordingly. The matter may be listed accordingly after vacation. Registry will do the needful in issuing reminder to call for the case record. Okay, sorry, case day. Okay, yes, I mean, no, nothing still. It is awaited only. Case diary. Registry look at connection. Okay.
I beg to mention item number 35. I don't want to press this matter because the matter has now become infructuous. It
It
was
has
a
al-
criminal revision petition
Huh.
against a transfer appeal order. So it's become infructuous because that lower court has already been transferred. We don't want to press the matter.
You are Mr. 35.
Item 35.
You are Mr.
P. Chaudhary.
P. Chaudhary. Not Mr. P. Chaudhary, the learned counsel for the petition. And it is submitted that he doesn't want to press the matter further as same has already become infructuous and accordingly pays to withdraw the same. Prayer allowed. The matter is disposed of accordingly on withdrawal. You are there in the other side. Your good name?
Yes, this one.
As this one, respondent ma kara didi ba? Disposed on withdrawal if matter become infructuous.
I beg to mention item number 7. My senior is out of the station and it is on the matter for that.
Item 7. Now see, it is a motion column, it was listed, but it will be definitely listed after vacation now.
Yes.
Okay. At a request made by the learning counsel for the petition, matter is adjourned, list accordingly after vacation.
Daily list item 1.
Only investigation will have over this. With all respect, elderly man 72 years, let her have a try, Melo. 2 matters, bail application, Melo. Definitely case diary needs to be sought for, Melo. If possible, Melo, or not, it doesn't come, we will not trace, Melo.
When you want.
19, Melo, fine. If case diary only, Melo, if possible.
Case diary, we don't have time, 19.
20, if
19, 20, we cannot.
72 years of age.
Yes.
If possible, Melo. Otherwise,
What nature of case?
Milo, that Ghush brothers
Also.
bank loan, Milo. He did not repay, Milo. Even those authorities are there, Milo. If it doesn't come, we will not trace, Milo. If they can.
You are appealing for the respondent.
Fine.
Special PP is on court number 3, Lordship, and one matter is going on. So after some time, Lordship, on his.
Well, only a date, Milo. If it doesn't come, definitely we will not trace, Milo. If possible, Milo, I leave it to your Lordship, Milo.
Some moments, Lordship, he will be here.
No, he
I have
is
no
for only for CD, you
CD.
just CD only?
Yeah.
If
Highly
it
obliged,
done
Milo.
19th. Okay.
But highly obliged, Milo. Highly obliged. Highly obliged. Same, 2 cases, same
7, supply list.
19 and 47.
47, Milo.
Lordship, my prayer is I have no instruction.
No, just he is saying that it's
Case
paying for
diary.
case diary. If it comes, it's okay.
Yes.
If it doesn't come,
We'll not
or-
trace.
or otherwise also if you remain busy or it cannot be
Yes, man.
heard on the 19th, later it will be after vacation only.
Yes,
That's it.
yes.
Yes, sir.
Highly obliged, man.
Obliged. Item 1 and 47,
1 and 47. Huh?
19 petition.
Yes, then.
Item 2.
LCR may be called for.
LCR. Yes, when it can
Letter
be
has been
fixed,
solicited, Lordship. Scan copy of LCR may be called for just after vacation, Lordship, when it is.
immediately after vacation. Scan copy of LCR be called for. At least immediately after vacation.
Obliged.
48 of the previous.
48. 48. 48 is connected with 24. 24, what? Which is 24.
24, Lordship, CD is available.
Oh, CD is available in 24.
This matter may be taken up together along with 20.
Yes, yes, okay.
Item 3.
84 plus 48.
48 to amendment, 24.
May it please the lordship. So this revision petition has been preferred against the impugn order dated 1/10/2024, your lordship. It is at page 26.
Page 26.
Your lordship, this is the impugn order. If may I read it, your lordship. Accused so and so is present with the learned advocate. Today, the date fixed for order on the petition being number so and so dated so and so, filed by the accused with a prayer for further cross-examination of PW1, that is the victim, and PW6, that is the IO of the case. In the petition, it is stated that during the cross-examination of PW1, some material aspects have been left due to inadvertency and also left to put some important suggestions. Accordingly, the prayer is made in the petition to recall the PW1 and PW6 for further cross-examination. I have already heard the learned advocate for the accused person and the learned special PP on the said petition. From the perusal of the case record, it appears that the PW1, the victim, was examined on so and so, and the PW6 was examined on so and so. After examination in chief of the above PWs, defense was given ample opportunity to cross-examine the above PWs, and accordingly, the defense side has availed the opportunity to cross-examine and cross-examine the above PWs. It also appears that the case has posted at the stage of defense witness, and at this stage, the defense has filed a petition for further cross-examination of PW1 and PW6. The ground stated in the petition is not found satisfactory and hence could not be considered. Hence, the petition being number so and so dated so and so is rejected and disposed of accordingly. Now, lordship, page number 23 is the petition, whereby under section 311, the accused petitioner have approached the learned court below for re-cross-examination of the victim and the IO, your lordship. Now, page 23, your annexer D, your lordship. If your lordship kindly takes the paragraph 3, your lordship.
Now, see, there is a question that when the case is of POCSO, in fact, you
Lordship.
cannot call the victim again and again before the court
Lordship,
premises to cross-examine. That is the issue.
lordship, that is true.
And what you have explained in the petition, why you need?
It's in paragraph number 3, page 23, your lordship. That during cross-examination, it had inadvertently been left to cross-examine the PW1 on some material aspects and to comfort and contradict with the earlier statements of the victim under section 161 of the CRPC in a proper manner prescribed in the Evidence Act, and also left to put some important suggestions which came to the light of the petitioner recently. Those are most essential.
Now the case is fixed for DW.
DW, your lordship.
When it is fixed for DW?
It's fixed on 20th of December, your lordship.
28.
2020.
20.
Yes, your lordship.
Okay. 20, then have you adduced any evidence by that time? Because the DW
No, your
was
lordship,
fixed on
it was-
24/10, in fact.
24/10, that day we took adjournment, your lordship, on that. And next date is fixed on 2012, your lordship.
2012.
Lordship.
Because the POCSO, we cannot
Yes.
pass any order on stay, in fact.
Lordship.
You may prefer an adjournment on the next week
Yes.
and
Lordship, may issue notice because I have also made the victim a party.
yes, you have to make, victim is the party, no, here. You are Mr.
G. Bodle, your lordship.
Heard Mr. G. Bodle, did any counsel for the petition? This is an application under section so and so in connection with so and so against the order passed by the learned special judge POCSO to breed. Dated 1/10/2024 in special case
Case
number 259 of
259.
2022. 22. Post issue notice corridor to the respondent number 1. No formal notice is required to be served on respondent number 2, as state has already appeared. However, the extra copies may be served during the course of the day. Ab tar agote likhiba hard MS SH pora kori dibo ha learned edition copy. As it is a case of POCSO, the same process will be there through jurisdictional police station,
Lordship.
routed through the office of the registry and the public prosecutor. And likhi diba. We're fixing it after immediately after vacation.
Yes, sir.
This immediately after vacation. You take steps within a 2 days.
Lordship. Obliged.
Yeah. Here, you need the LCR also, or LCR is not required.
Lordship may call for the
LCR may be called. Scan copy of LCR be called. Be called.
Much obliged.
Item 4.
My lord, both can be taken up at 2. Conducting Council Mr. Ahmed will next before division bench, my lord.
At 2.
Good.
We'll try.
A report
Yes,
was-
just a second.
A report was called for that we have received only one page report. Lordship.
Your report was called for.
Yes.
Sorry, may I ask you?
Lordship. may
Let it
carry-
be taken up at 2, my lord.
He's
He's on next.
insisting at 2.
Yeah, okay. Deeply obliged, my lord.
Item 5.
May I please, your lordship? Before crossing over, lordship, the order passed on the Jimma lordship. That lordship will kindly see on page 44.
I think about this.
40.
Page 44, lordship, this is the order of my Jimma lordship. They are kindly come to third paragraph, lordship. The Jimma petitioner are represented. The IO submitted to the Jimma report stating that one iPhone, one so and so, one are were seized from the possession of the accused Sri Ranjan Sinha, the present petitioner lordship. The IO submitted that no document like text invoice or case memo, etc. in respect of the seized gold color neck chain and bangles have been produced by the Ranjan Sinha to verify his claim. As such, the IO has submitted that the seized items are required for lordship. The gold item, lordship, he could not submit any document. Lordship, for that reason, I have stated in the petition, lordship. Lordship, you kindly again look. Small paragraph, please.
Page 9. is it? Six. Six.
Paragraph 10, lordship. Lordship will kindly see page 8. Page 8, lordship. The petitioner basically said that the said gold articles, neck chains and bangles are the gift received by the petitioner from his relative, friends, well-wisher at the time of his marriage ceremony, lordship. No invoice or case memo in respect of those golden articles or also received by the petitioner from those persons who gifted those things to the petitioner during marriage reception, lordship. And the one thing is evident that lordship, that those particular things which I'm claiming, lordship, were seized from my possession, lordship, and it was duly seized and seizure list was made at the time of seizure, lordship.
Is it a case of theft or what?
No, lordship, it is that cyber crime, lordship. That they regarding that phones and all that I'm not claiming, lordship. Lordship will kindly turn to page 13, lordship. Kindly turn to page 13. The prayer portion, lordship. I'm not claiming the phones, lordship, because it is a cyber crime, lordship. The phone might require for further investigation, lordship. I'm not claiming that. Lordship will kindly see the allow Jimma golden color metallic neck chain 72 gram, gold chain metallic neck, so and so, golden metallic color bangle weight 70 grams and golden metal bangle and 17 and approximate case amount, lordship, that is 130. Regarding the phone and all, lordship, that I'm not claiming. Lordship. 2 phones were seized from my possession that might require for further investigation as because the case relate to the cyber crime, lordship. So remaining that part, lordship, that were gifted at the time of marriage ceremony, lordship. So that case memo and text invoice, lordship. Normally nobody keeps that, lordship, once it becomes old, lordship. And the evident part is that, lordship, it is seized from me. And seizure list was prepared at the time of seizing those articles. It was from my body, it was seized.
Yes, and what is the
His lordship report is here also.
The last day on motion is lordship was inclined to grant it, lordship, on last motion. But for the learned to be short time for it.
এইটো কি হ'ল মই ভয় হৈ গলো মোৰটো দেই নেকি
No, tomorrow. Yes, direct.
এইটো দেই নেকি
Yes, submitted, I think, similar kind of report, in fact.
Yes.
And why those articles? I mean, the gold chain or whatever it
Cash
may be,
amount is already deposited in the treasury also.
cash amount.
Yes,
Okay, then
that
cash
is
amount is
primary.
other the the
Required for further
further
investigation.
investigation. What about the
Well,
gold metallic
Gold
chain and
metallic sales, because non-receipt of the same. So there is a
no? Can you tell us out why it will be needed for further investigation?
that part is not very clear.
That part is not very clear. I mean, obviously, the mobile handset and other things
Yes.
will be required or may be required.
I'm not claiming that. That's
But
not in-
the gold materials, I don't know why it is there.
Not sure. That is. I'm
It's
not
for
sure.
any further purpose of whether they is going to send for FSL and all.
Yes.
These are also not here. What kind of investigation is going on or whether it will be required for further investigation, how and why.
Hmm.
And the question is that
Should they be sent for FSL whether
that is also not here. They have not taken any step for.
In
And
that case-
they don't know where these are gold or gold-like materials. I don't know. That I cannot say.
whether it is fake gold or maybe for that purpose, not sure.
Golden color metallic neck chain.
Yes. Might
And
be
if you see
stolen
by
one
the
also.
gram, that is the 72 grams. 72 gram is quite a
That's,
big chain, I think.
yes,
The-
that is what that's. Might be the stolen one, fake gold also. Not.
Yes, does not relate to any theft of item logic. It is a cyber crime logic. That duping person logic that is like a call center logic. And so the further investigation of stolen ornament logic, that question does not arise as because the case is not of the subject matter of the FIR is not of that logic. It is of the evidence is that it was seized from him logic. Duly seizure list was made. And the only thing is that I could not produce the document logic. That how one will keep old articles in document logic. I think nobody is keeps logic such document. Yes, ma'am. No. And moreover, logic that mobile phone logic, I know it logic that will require for the further investigation. So mobile will not claim logic. That in my prayer portion it is very clear logic that will not stop for.
There are two accused persons.
But many accused persons are there logic.
Before or no, only one petitioner.
Here
Here
only
is
one.
Rajan Siddhan.
Yes.
A lot. Many accused persons were arrested. A call center were raided, Lordship, and many persons were involved in this case, Lordship. Somebody were also innocent, also they were working in the call center without knowing they are also, but many people, that is a different aspect, Lordship.
So the lordship in peer person at page 35, annex of 4, and page
30.
37 lordship.
37.
Yes.
Hmm.
And there is a note in the order that however, the last portion, however, the petitioner may approach the IO anytime for the Jimma of these articles, and the IO shall do the needful with regards to these articles as per provision under section 102 CRPC, if the same are not required in the investigation of the case.
No.
So he may again approach before the IO.
No. It will corruption is second subsequent. That was very clear, Lordship. So we have annexed this order, Lordship. After that, we approached their Lordship. Not giving the Jimma is that we could not produce any document, Lordship. That clearly revealed from the subsequent rejection order, Lordship. After rejecting this order, we went to IO, but without document, he is not willing to hand over the thing, Lordship. So we have subsequently we again filed a Jimma, and that was also rejected because of that ground only, Lordship, that we could not produce the document.
We have any seizure list here also. Seizure list, sir.
Yes.
Seizure list we have annexed, Lordship, 33, page 33.
1 3.
33. Lordship.
33.
Disposition.
This is a 33 lordship is the seizure. Other thing also there lordship, there are two mobile phones were there, SIM card, iPad, that we are not claiming lordship.
Point
because that-
number 7, Lordship.
Mm.
Point number 7, and golden color metallic neck chain, one weight 72 grams approx. And again, golden color metallic neck chain, 11 grams. And then again, golden color metallic male bengal, that is 70 grams. Lordship. 3 golden nuggets.
Remaining lordship, that iPad, SIM card, two mobile phones, that we are not claiming lordship. That we know very well that it will require for investigation lordship. That only the gold ornaments lordship.
Yes, what are any other submission?
Nothing that much. Because everything is there in the report actually.
Heard Mr. S. Munir, the learned counsel for the petitioner, and also heard MS S.H. Bora, the learned additional PP, appearing on behalf of state respondent. This is an application back in Likhitivo, so and so. For setting aside and quashing of the impugned order dated 13/6/2024 passed by the learned SDGMS Kamrup. Learned SDGMS number 1 Kamrup Metro in connection with Cyber PS Guwahati case number 08 of 2023. Under section so and so, whereby the prayer for Jimma was rejected. Jimma rejected of the seized golden articles and cash amount of the petitioner. Report received from the IO. There is the same. Next, it is submitted by Mr. Munir that during the search operation, during the search and seizure, the articles, no, equipment.
Page 33. 33 and 34. 34 is the original.
Search, one gold color metallic neck chain, weight 72 grams approx. Number 2, gold color metallic neck chain, one gold color metallic neck chain, weight 11 gram approx. One gold color metallic bangle, weight 40 gram approx.
70 grams.
Oh, sorry, 70 gram approx, and one gold color metallic bangle. No, angle, two numbers of gold color metallic bangle, weight 70 gram approx, along with and cash amount of rupees 1,32,000 was seized from the possession of the present accused petitioner, along with the other articles like iPhone, SIM card, iPad, etc. He, the petitioner, earlier filed a petition seeking Jimma of the gold articles and the cash amount of rupees 1,32,500. Sorry, 1,32,500, which was seized from his possession. But the learned court below, by order dated
13/6/2024.
Page 44.
Page 44. Lord.
13/6/2024 had rejected the prayer of Jimma, considering the report of the IO, wherein it is stated that the petitioner could not produce any receipt, etc., for those articles, and also that may be required for further investigation. And full stop. And after rejection order of after rejection order passed by the learned court below, the present petition has been filed seeking the Jimma of the gold articles and the cash amount of rupees 1,32,500. Full stop. Mr. Munir further submitted that this is a case of cybercrime, and hence he is not seeking the Jimma of the other articles like iPhone, SIM card or iPad, etc., but only the gold articles, and the cash amount is cash amount is sought for Jimma by the petitioner. Mr. Munir further submitted that he could not produce any money receipt, etc., before the investigating officer, as these are not available with them, and those articles were received by him only at the time of his marriage as a gift, and hence there is no receipt. And hence it is a fact that there are no receipt of those articles are with the petitioner. He further submitted. Accordingly, he submitted that these articles may not be required for the further investigation of this case, as the articles cannot be the subject matter of the further investigation of this case, wherein the crime is where the offense alleged is against him, against the present petitioner, and petitioner is of cyber. Option mil ideas. Next paragraph. MS Bora, the learned additional PP, submitted in this regard that from the report of the IO, it is seen that the articles may be required for further investigation of this case, and in the same time, the Jimma could not be given to the present petitioner as he failed to produce any receipts, etc., before the IO. However, the learned court below, while rejecting the prayer for Jimma, directed the present petitioner to approach the IO.
No, that was earlier order.
Huh?
That was earlier order.
Two orders are
After
there.
that, the subsequent Jimma was filed. Okay. That was earlier. Earlier observation. Okay.
Two orders are here.
Two orders are there. There are joint petition lordship. Many accused are there lordship. In one case, while rejecting Jimma earlier, that observation is given to approach the IO. When we approached the IO, he did not hand it over the thing. So we have subsequently filed the Jimma petition, and after rejecting it, we have approached the honorable court lordship. That order, that was of order lordship that reflects on page 38. Huh? Or last order to that.
Earlier
Our
one is
rejection is on in
35.
our rejection there is no observation.
No, in 6/3/2024, which is the order.
13/6/2024 is out.
No, 3/6/3, sorry, 6/3.
That is the earlier order. Lord.
There you are not there.
No. Huh? There was jointly.
He was there, Lordship.
Jointly, Lordship.
He was there.
This is the subsequent one, Lordship. The 13/6 is subsequent. Earlier, that rejecting the observation was given to approach before the IO. When we approached, we did not hand over that one, Lordship. And thereafter, Lordship, we have filed this specific. This person has filed it on 13/6. It was rejected.
It is a last line to. Last line to. We're rejecting the prayer for Jimma dated 6/3/2024. The petitioner and others were directed to approach the IO with a fresh prayer for Jimma. Stop. Next para. In this context, Mr. Munir submitted that after rejection of the earlier rejection order dated 6/3/2024, the petitioner along with others again approached the IO seeking Jimma of those articles, but the IO refused to hand over the same as the petitioner could not produce any money receipts, etc. And thereafter only, the petitioner again approached the learned trial court below with a fresh petition for Jimma, seeking a petition for Jimma for the gold articles and the cash amount, which was also rejected by order dated 13/6/2024. 24, and hence the present petition has been filed. Next para. Hearing the submission made by learned counsel for both sides, I have also produced the case record and the report submitted by the IO along with the annexures. Poster. It is the admitted fact that those gold articles and the cash amount of rupees 1,32,000 were seized from the exclusive possession of the present petitioner along with some other articles. In the report of the IO, in the report of the IO, it is mentioned that the is that the ownership of those articles are yet to be verified and by the IO, and in the same time, it may be required for further investigation of this case. Further, it is reported that the petitioner could not produce any receipts, etc., for the said articles. At the same time, 1,32,000 has already been deposited. Like? Further, the cash amount of 1,32,500 has already been deposited in the government treasury poster during the investigation of this case. Next para. But it is seen that there is no mention as to why the gold articles, gold articles will be required for further investigation of this case. As prima facie, it is seen that those articles are not the subject matter of the present case. In the same time, it is also seen that there is no mention as to whether those gold articles were sent for FSL for examination or whether it will be required for further investigation in the case. The IO simply submitted a report that the materials could not be handed over to, could not give Jimma could not hand it over to the present petitioner only because he could not produce any receipts, and in the same time it may be required for further investigation without mentioning anything in regards to simply so and so full stop. In view of this, this court is of opinion that as there is no full stop knowledge. So further it is seen that till date there is no other claim made by any other persons for those gold articles which were seized from the person of the accused petitioner, nor there is any allegation of theft against the present accused petitioner for those articles. In view of the discussion made above, I find that the present petition is allowed, setting aside the order passed by the learned trial court below, dated 13/6/2024, and 24, and the present petitioner is hereby. You may file a fresh petition before so and so. It will be assess the quantity amount. Or directed to file a fresh petition before the learned trial court below, seeking Jimma of these articles, and which will be allowed. To allow for any time will do. Okay, I'll pass the order later in the DSO. You may phrase a file application before so and so, it will be considered, and the amount of, if any bond is required, then it will be there. I'll pass the order in that regard. Your petition is otherwise allowed.
Much obliged, your lord. Much obliged. Much.
Last one, I'm not getting in my law.
My lord,
Yes.
with your lordship indulgence, with regard to item number 1 and 47, the lordship has fixed the date on 19th.
Mm.
1 day only, lordship, it is quite impossible, lordship.
I
Because
know.
we
They are
are going-
insisting that they don't have any say if 19th, the CD not received.
Not only
And-
CD will file written objection to their petition also, lordship. So for filing written objection, at least 2 weeks time is required. And that is the difficult, lordship.
Okay, 19 on 19 before 19, if you can file your written objection, that will be accepted. Just
I cannot file it. Today is 17, only 1 day is left, lordship. And because of this ongoing cases, but cases, lordship, I have preoccupied with those cases, lordship.
Sure.
Therefore, lordship, in the morning, lordship, I went to court number 3, lordship, and item number.
No,
two,
she was,
Yes.
she was
With their
submitting, in
consent.
fact.
Yes, with their consent.
And I thought that it is only 19th,
Today is
just
17, only 1 day is it.
CD also not received, I think. CD will be not.
Not possible, lordship. Let the matter be after vacation, lordship. I'll inform them.
Now to, as he insisted, he's 72 year or 80 years old, whatever he was submitting in the morning hours.
In the lordship.
Mm.
Offense is very grave in nature, lordship.
Mhm.
Crores of rupees has been diverted,
Mm.
more than 24 crores rupees.
Can he be, Mr. Mahajan can be informed? Otherwise, it is already order has been passed. Huh? Can he be informed now?
I'll try to find. It's Julius, his associates.
Acha.
Right.
She's trying to call him, sorry. If you can.
Hello.
Now, she submitted in the morning hours that she
Right.
don't have any instructions, in
Yeah.
fact.
Right.
Now, he is saying that we don't have any objection even if CD is, reach or not. So
Let
that's
their
what,
submission, then let it be on record, lordship. Let their submission be on record, lordship, because on that day, on 19, he may take some difference then. If
let him call, we are calling him. Okay. We'll try to inform.
Hello.
Item 6.
May it please me, Lord. My Lord, we are moving this petition under section 528 for quashing of the FIR and the charge sheet, subsequent charge sheet. But at annexure 1 is page 16, my Lord, is the FIR.
Page 16. Yes.
To the officer in charge, Bharlumuk Police Station, dated so and so. Sir, I beg to state that I am the General Secretary, Center of Medical and Sales Representative Union, Northeastern Region. Yesterday, Mr. Biplab Roy, Zonal Sales Manager, Glenmark Pharmaceuticals, on behalf of the state company, asked me to come to Marwari Hospital to discuss about illegal dismissal of 5 numbers of medical representatives working at Agartala. I reached there at about 2:30 p.m., but without initiating any discussion, the said Biplab Roy threatened me and warned me not to agitate against the above dismissals. Otherwise, he threatened me to finish my life. Additionally, he threatened to kill me by engaging unscrupulous people. Due to physical ailment, I could not lodge the FIR yesterday. Therefore, you were requested to investigate into the above incident and register a case against Biplab Roy and to take legal action. Now, this is up. My police station is just near my place. I lost the FIR after 27 hours. That is one aspect of the matter. Again, in his 161 statement, my lord, this is at page 28, my lord.
Yes.
In his 161 statement, the informant says, I'm working as a General Secretary of the Northeastern Region, Center of Medicine and Sales Representative Union. When we protested against illegal dismissal of many of our employees at Agartala by Biplab Roy, Zonal Sales Manager, for his own interest, he lodged an FIR against me at Tripura Agartala and Panbaza Police Station of Guwahati and Bharlumuk Police Station for leading the agitations. There is reason to protest by our people. And on this subject, Mr. Biplab Roy called me to Marwari Hospital for discussion, and in front of the hospital, he behaved with me indecently by using hard language. He threatened me not to protest and make telephone call, and as such, I lost the Ejahar. Now, I mean, her FIR and a 161 statement, the threatening to kill him physically is totally missing. In 161 statement, it is gone. It has not been corroborated. Why I'm saying this now, The two other witnesses, my lord. Can you see the 161 statement at page 20? First one is at page 25, annexure 3. Here's one Bhaba Haloi. What he says, I'm a resident of the above address. Yesterday on 2/3/2017, when I went to Marwari Hospital for my personal work at about 2:30 PM, I witnessed Biplav Roy in a fit of rage chasing Rahul Purkastha and with death threat warned him not to act as a leader in support of the dismissed employees of the company at that time. I remained present and observed the above incident. Again, at page 26, another witness, I reside above the above mentioned address. Yesterday, 2/3/2017, when I went to Marwari Hospital to visit one patient, I saw Sri Biplav Roy chase Rahul Purkastha behaving in indecent way on the road in front of the hospital and threaten him against any kind of agitation for dismissed persons and phone call. If it is done so, then he'll be killed, and also threaten that he has arranged people for killing. I know both of them are persons of the medicine company. Now, two supposedly independent witnesses at 2:30 PM on 2/3/2017 have got work in a Marwari hospital at the same time. I am a zonal sales manager. I have got my duties. Some people are not performing, so I had to dismiss them. These are the Indian people. They get together, they foist the case against me before the Bhorlum police station. But what is more intriguing, that in the charge sheet, this is that page, my lord, 21. Charge sheet says at annexure 2, page 21, the brief story of the charge sheet is that on it should read 2/3/17, the general secretary of so and so, Mr. Rahul Purkastha, of son of so and so, resident of so and so, stated that on 2/3/2017, the zonal sales manager of Glenmark Pharmaceuticals, Biplav Roy, called him to discuss about illegal dismissal of medical representative at Marwari Hospital. At about 3:30 PM, he put him in fear of death, by death threat, and warned him not to make phone calls and agitate against the illegal dismissals. As per the FIR, the case is registered and investigated into the matter. After visiting the place of occurrence and after investigating, on the strength of the sufficient witness on evidence, a case has against accused Biplav Roy under section 341/506 is established. Accordingly, he was arrested. Since the allegation against the accused are bailable, the accused was released on bail upon surety given by a local and reliable person. Moreover, the charge sheet, along with a sketch map and bail bond, is forwarded here to the Honorable Court for trial. The witnesses mentioned in column number 6 will depose before the court. Now, number one, I am the zonal sales manager. I shall never call an employee of all places to Marwari Hospital to discuss these things. I'll call him to my office. What has happened in the charge sheet, my lord? I came to know about this case only after I received summons from the Honorable CGM of Kamrup Metro. I reside in Mumbai now. I was transferred on promotion to the head office in Mumbai. So I come and sincerely appear before the trial court, and I enter appearance. I was never arrested. I was not even called to the police station. So who has been arrested and who has been let off on bail bond and who has signed my surety? This is a very serious matter. In charge sheet, they have said that I was arrested. I don't even know about the matter. Only the records will reveal who was arrested and who was let off on a bail bond. Now, this is a very tainted investigation. It is very apparent on the face of the record that these two interested witnesses.
No, that is not there. This is a bailable offense. That's why when you were there in the police station.
I was not there. I was not. That is what I want, my lord. I was never asked to come to the police station. I don't know about this case. The first time I know about this case is when I received a summons from the CJM. It's a very serious matter. Who has signed my bail? He says that accused is released on bail upon surety given by a local and reliable person. Who are these people? This records needs to be looked into, because if it is so, it's a very serious matter. And if I am on affidavit, if I am not, if I'm making a false statement before the court, my petition will be dismissed. It's a tainted investigation. They've got together. These two witnesses at the same day, same time, they come to the Marwari hospital. Did the police find out from the CDR, the call data records of the previous day, where I have supposedly called him to the Marwari hospital? No, there's absolutely no investigation. Who was being called to the police station? It is not me. I didn't even know about the case.
Please.
So let us at best also may call for the case record. Notice should go to respondent number 2. Thereafter, everything will be clear.
No, my lord, because I'm in Mumbai, my lord. I've come many times before this, before the trial court. Sincerely, I've come and appeared because I'm a peace-abiding, law-abiding citizen. I must be protected at least until the returnable date, my lord. Again, I have to come from Mumbai and spending my own money.
Next date is fixed on when?
7th, 8th of January just after the reopening. Any day.
No. Your next date is fixed on
On
when?
7th of January. My lord may protect me until 8th of January. My lord may hear the matter. If the records say that no, I am making a false statement before the court, my petition will be dismissed outright. And this 341, wrongful restraint. How have I wrongfully restrained as per the charge sheet and the FIR? And if I'm not corroborated, me being an informant, I'm the accused, but he being the informant, if he has not in 161 statement, he's totally forgotten about the death threat. And he's admitted in his, it's a pure case of vendetta. In the FIR, he's admitted that I've lost cases against them for agitations and all against the company. In Agartala and in Guwahati, in Panbazar, Guwahati. Where are the records? Where are my call data records? The police have not investigated to find out whether I have actually made the call and invited him to Marwari hospital on the roadside. And me being a zonal manager, shall I call my employees to the roadside? A very concocted and made up story, man.
You are Mr.
I'm R. Sharma, senior counsel.
Mr. R. Sharma, senior advocate, assisted by
Mr. E. Ahmed.
Mr. E. Ahmed. The counsel for the petition also had MS SH Bora, the learned additional PP appearing on behalf of state respondent. This is an application under section 528 of BNSS for setting aside and washing of so and so quality. It's a pending before JMFC Kamrup M.
Right.
So
Yes, Doctor.
issue to the respondent number 2 to register AD and as usual process. No formal notice is required to be served on respondent number 1. However, extra requisite copy may be served during the course of the day. Mr. Sharma, the learned senior advocate on the interim prayer, where he submitted that he submitted that the false and concocted case has been lodged against him, and he came to know the entire incident and about the case only after receiving a summon from the learned CGM Kamrup M.
Learned special judicial magistrate.
Learned special judicial magistrate Kamrup M. And appearing before the learned court below, he came to know about the same. But surprisingly, in the charge sheet, it is seen that he appeared before the IO and he was released on bail. With security given by the local reliable person. Whereas he never appeared before the IO, nor he was ever arrested in connection with this case. He further submitted that presently he is residing at Mumbai and is finding pressing difficult and accordingly pray for stay of the further proceeding till the next date of listing. Prayer allowed. For the scan copy of the LCR for the scan copy of the LCR. List the matter accordingly after due vacation and date.
Date may be fixed. Doctor.
Date
may be fixed.
Date may be fixed. 27th of January. 27th of January, so and so. Till then, he further. How many with accused? You are only the only.
I'm the only accused.
The further proceeding in case number so and so, pending before the learned GMFC so and so. The state.
Special magistrate.
Judicial magistrate.
Special judicial magistrate. The state till next date of listing. You take steps on the respondent number 2. We are also calling for the scan copy of the LC.
Much obliged.
For the hearing item 15.
One, fine. One, five, I don't know, 1, 5 is not here. Ahmed, at a time besides the one. Actually, most probably, he, huh? No, Kuru, I mean, other matters also here. None appears on call for the petition. We have received the scan copy, no? Scan copy of the case record has already been received. List the matter after vacation. It's a charge-sheeted one, I think.
That's that one.
List the matter after vacation. 16.
16.
So I've been for 16. And Ahmed and I search for it. Yeah. Huh? No, he's not here. 16, also same order. His scan copy. 16 you are.
16.
You are for the respondent, no? Petitioner is not appearing. Petitioner to respondent. Petitioner is absent on call. The learned MS, hard MS, MDECA, learned counsel appearing on behalf of Mr. S.C. Kyle, the standing counsel DRI. Scan copy of the case record has already been received. List immediately after vacation. The charge-sheeted case, I think.
Yes, sir. I do apply.
17.
Same
with 15. Same.
17, same order. After vacation. Immediately after vacation.
18.
Yeah, please. 483 application lordship, the commercial quantity, some tablets were recovered from the possession of the accused person lordship, and 2 accused lordship. And my name is appeared in the FIR in number 2. And but the I kindly come to page number lordship 19, the forwarding report lordship.
19.
19 lordship. And my lord kindly come to 20, next page lordship. Page number 20, ground of arrest lordship. The accused person are the FIR name accused person, and total 29,000 numbers so and so. 2 cases 907 grams of suspected methamphetamine tablets was recovered from the joint possession of the arrestees, kept concealed in a black color bag. Lordship. My lord, here in this case, lordship, 1 bag is mentioned in the lordship as per the forwarding report lordship. And how can lordship and 1 bag 2 person is lordship possessed by 2 person at a time lordship. And another aspect lordship, the FIR petition, FIR accused number 1 Saiful Islam, and he is staying in a rented house lordship at Dhirenpara area lordship.
Who? The other accused.
Accused number 1 in the FIR lordship. Saiful Islam, other accused.
Achha.
On
Other
that very
accused.
day lordship, and he went to visit his room lordship, and that because they have the good relation and in the same as boy lordship. And from his room lordship, this tablet has been recovered lordship. But otherwise lordship, and he is no way connected that because he is nothing no. And such type of tablet is kept in his room lordship. So more than 1 year lordship in custody. And the local person from Dhirenpara, he is the permanent residence lordship. And my little
No, your petitioner is from Dhirenpara.
Local person lordship, and their house is Kotabari area lordship. And the other accused, and he said he is staying in rented house at Dhirenpara area. So my lord, my submission is more than 1 year. And any stringent condition may be imposed in the meantime. Charge sheet has been submitted, lordship, trial proceedings started, lordship. My submission is lordship.
My lord, so it's that a scan copy was called from, my lord, along with the status report, my lord. And as per the status report, my lord, the next date was fixed on 11/9/2024 for copies and, my lord, consideration of search, my lord. Search is yet to, my lord, same as per the last status report, my lord.
So it, from your report, it is up to 11/9 only.
11/9/2024, yes, madam. On that time, it was fixed for copy and production, madam. So after furnishing the copy, madam, charge will be framed.
Lordship, chargesheet already been laid in Lordship.
Yes, CS is dated.
Even after, before CS Lordship, I have submitted this petition Lordship. and subsequent-
CS kita phone
That's what the scan copy has to do. And the scan copy is there, Lordship. I have filed before chargesheet.
Oh, acha, acha. Then do you want any, Mr. Borua, if
Scan
it is
with
for
your-
11/9,
Madam.
then updated should be called for, or
Madam, updated have to be called for, madam.
we are not in a position to say anything
Lord-
now at
Lord.
present.
And in the meantime, Lordship, I will obtain the certificate copy Lordship. And all the,
Probably, madam, on 25/2024, search is submitted, madam. As per the status report, madam. But madam, search is not, madam, forwarded along with the scan copy of the record.
It's not here only.
Not, madam.
my lord, and they are in custody Lordship. Chargesheet is already laid in May Lordship, but yet still today Lordship. Charge was not framed Lordship. So let this is-
No, but that is madam up to 11/9. Madam, what happened after 11/9, that we do not know.
They are in custody Lordship and production every 14 days they are continuing their production Lordship. But they are not in outside.
Heard Mr. F. Hawk, the learned counsel for the petition, and also heard Mr. R.J. Borua, so and so. Scan copy of the case record is received, but it is only up till 11/9/2020. Oh no, 24, when the matter was fixed for
Production and copy.
production and copy. Accordingly, it is submitted by Mr. Borua that it is not known as to whether it is not within the, it is not known as to whether the charge was framed or any witnesses has been examined during the period of 2-3 months. Post Mr. Hawk, the next para, Mr. Hawk, the learned counsel for the petition submitted in this regard that the accused petitions are behind the bar since 23/11/2023. And as per instructions, till that no prosecution witnesses has been examined. Next para. Considering this submission made by learned counsel for both sides, let updated case record be called for along with the present status report as to whether, with a report as to whether the charge has already been framed or any witnesses are been examined by the prosecution. It will be, sorry to say, it will be after vacation only. We don't have any date now.
The 21 and other accused Lordship are 21 January. Lordship after.
For the other accused, 21
Other-
January.
21
Then
January.
okay, then we are fixing it.
2025.
21st of January.
Lordship.
It's 21st.
Published Lordship, published,
My lord,
published.
my lord, I'm very sorry, 15 and 17, my lord. I was asked by court number 11. And in the
Now it will be not possible now. If
Lordship,
it time permits only, then only.
my lord, as last item, my lord, kindly, my lord.
Already order has been passed in fact.
Last item, my lord, kindly, my lord.
We'll try to it, otherwise we cannot say. Lots of matters are there.
Yes, ma'am. Last item, my lord, just if I
We'll
can.
try only with that much only I can say.
9/9.
90.
May I proceed, Lordship? Lordship, FIR page 13, Lordship, 13, Lordship. Petition is
Here also we have received the LCF.
Actually, receive my lord.
behind the bar for 281 days as on date, Lordship.
281 days.
Yes, Lordship. The trial is going on currently. FIR page 13, 13.
1-3.
Yes. Already 7 witnesses are examined, Lordship. There remains only 4 witnesses and all are official witnesses.
How many witnesses already examined?
7, Lordship.
7 already examined.
Yes, Lordship. And there remains only 4, Lordship, and all are official, Lordship. And now, Lordship, since 27/9/2024, Lordship, no witnesses has been examined, Lordship.
Victim is already examined.
Yes, Lordship. This 23, Lordship, chargesheet, Lordship, list of witness, Lordship. 1 to 6, Lordship, page 23. 1 to 6 and victim is examined, Lordship, and 7, 8, 9, and 10, Lordship are to be
Remain.
examined, Lordship.
Are yet to be cross-examined.
Yes, sir.
Yes,
Lordship, the petitioner is 19 years old, Lordship, and considering the age and, Lordship, period of detention, Lordship.
19 years.
Yes, Lordship.
Victim is my lord, aged about 4 years old, my lord. 4 years old child, my lord, and out of 10 witnesses, 5 witnesses have already been examined. Victim examined is PW3, my lord, and she is implicated, my lord. She is implicated. So it's a case of POXO, my lord. At this stage, my lord, I oppose because my lord, lordship will have to consider, my lord, on the basis of material and record, my lord. In this search with case, my lord. And my lord, the service is complete, my lord. She is appearing for the respondent number. Informant. I don't know.
Yes. What do you want to submit? What do you want to submit?
Bail should not be granted at this end.
Five witnesses.
Neighbor only. Victims, neighbor only, her neighbor only.
Lordship, 7 witnesses are examined, Lordship.
7.
Yes. Only there remains, Lordship, IO, doctor, 2 official, Lordship, and all the private witnesses are already examined, Lordship, including victim, Lordship. So, Lordship, since 27/9, Lordship, no witnesses are coming to the court, Lordship. So, my humble prayer, Lordship, only 19 years old, Lordship. Considering his
19 years old, accused is 19 years old, my lord. Victim is 4 years old.
at his tender age, Lordship, I have nothing to say.
Medical is also not good side, no? Medical is also there.
Yes, they are 4 years old child.
At any condition, Lordship, the conclusion of the trial, Lordship.
You are Mr. S.
Yes, along.
S. Alam. Pardon, Mr. S. Alam, the Learned Counsel for the petitioner, and also have Mr. R.J. Borva, the Learned Additional PP, appearing on behalf of state respondent. And MS K. Fukon, the Legal Aid Counsel, appearing for the Learned Legal Aid Counsel, appearing for the respondent number 2. Scan copy of the, this is an application, so and so like it. The scan copy of the case record has already been received. Artful site. Next part, it is submitted by Mr. Alam, the Learned Counsel for the petitioner, that he is behind the bar since last 281 days, and case has already been charged sheeted, and out of 11 numbers of witnesses, 7 witnesses have already been examined by the prosecution, including the informant and the victim. Only official witnesses are left to be examined full stop. He further submitted that the accused is of only 19 years of age, and he being the permanent resident of this address locality, there is no chance of absconding. More so, since 27/9/2024, no witnesses have been turned up, and the case is still and turned up, and the case is still at the evidence stage, where four witnesses who are the official witness, and 4 witnesses are yet to be examined by the prosecution. Next paragraph. And accordingly, he submitted that considering the age of the accused petitioner as well as the length of detention, he may be enlarged on bail. Next paragraph, Mr. Borba, the learned additional PP submitted in this regard that the witnesses who have already been examined had implicated the present accused petitioner, especially the minor victim, who is only 5 years old at the time, 4 years old at the time of the alleged incident. Accordingly, he raised objection and submitted that submitted that it is not a case to fit case wherein the accused can be granted with the privilege of bail. Next paragraph, MS Focon, the learned legal aid counsel for the respondent number 2, also submitted that considering the nature of offense alleged against the present accused petitioner, comma, the evidence of the minor victim and the medical medical report, etc. She raised objection and submitted that the bail should not be granted to the present petitioner at this stage. Next paragraph, considering the submission made by learning counsel for both sides, materials in the case record and case diary, the have the scan copy table DVD. Yes, only here. No, more. And materials listen. The evidence of the materials in the case record and case diary, evidence of the minor victim, this the medical report of the victim, and other aspects of the case. I do not find it a fit case to extend the privilege of bail to the present accused petitioner at this stage, and hence the same stands.
Review 1.
And that LCR is called for, and LCR is received, I think.
LCR, my lord, it is not cause this, my lord, LCR not shown, my lord. 21.
Still awaited, in fact. Why it is awaited? Because from the order sheet itself, it is seen that it was called for on 24/9/2024, but till that is awaited. Scan copy. We have not received the scan copy here. It's a case of commercial quantity.
Commercial quantity, but 1 year, 8 months, 1 year, 6 months have been elapsed in custody.
So we need this scan copy. otherwise. Heard Mr. H.R. Chaudhary, the learned counsel for the petition. And also heard Mr. R.J. Borro, the learned edition PP so and so. From the office note dated 12/12/2024, it is seen that the scan copy of the trial court is still awaited. Though it was called for by the registry on 24/9/2024. Accordingly, the registry is hereby directed to issue reminder to send a scan copy of the LCR on or before scan copy of the LCR, and which is it should be reached on or before the next date of listing. It has to come from Karimganj. Whatever Karimganj, because scan copy only you have to send.
To online one.
Whatever, yes, online only. So 24/9/2024, it is awaited. I mean 24/9/2024, it was sent, but since till after even after a lapse of about around 3 months, it is not received. We are issuing reminder, let us see.
Matter will fixed on 3rd of January.
3rd of January, the reopening day may not.
Reopening day on 2nd of January.
Let us fix. 2nd is a holiday, in fact. So don't keep it on 3rd. Let it be in 6, 7 or whatever. 7 we are fixing. 7 of 7.
Item 24 along with 48.
May please your lordship.
In 24 and 48, in both the matters, you are appeal.
Yes, madam. Well, the item 24, the wife, and 48 is the husband, ma'am. Both husband, wife. Here, my lord, the
48 is the anticipatory.
my lord, both are my lord regular bail, ma'am. Regular.
48 is also regular bail. Oh, okay then.
Well, today is 51 days, and the charge is here, my lord, 21B, ma'am. My lord, the affair is case 14. Then, my lord, the SI, yes, my lord. SI of my lord Bangalmara outpost under the Dipuria, my lord, police station conducted the search operation in the house of the present petitioner, and my lord found that 12.34 grams suspected heroin, my lord. That is the case, my lord. And at the time of search, my lord, the husband was absent and wife was present. And police taken to the first time the wife to the police station. And wife said that
So she got arrested on 28/10.
same day, madam.
Acha.
Same day, and madam, the investigating agency told the wife, "You call your husband. If your husband come to the police station, I will release you." Then husband call about telephone. Then you come, and he honestly, my lord, came there. And when come, my lord, husband also arrested, my lord, but wife is not released. From the same forwarding, my lord, there behind the bar, and this lady, my lord.
Forwarding is that page?
Forwarding, my lord, that is page, my lord, 16, my lord, 16. And next page, my lord, that is
Grounds of arrest.
yes, my lord, ground of arrest. Both are in same forwarding, my lord. Suspected, my lord, that 12.34 gram heroin, my lord, and wife saying that, my lord, wife is not there. And my lord, in absence of husband, initially whether husband would have been present, wife perhaps would not be taken to the police station, my lord. And she's mother of 2 minor child, my lord. One is 6 years and one is 4 years old. And 51 days to remain. And husband, my lord, also here, my lord, same day, 51 days. And my lord, 9 days left, my lord. So I'm praying, my lord, only length of detention may be considered, my lord, because court is going to remain holiday, my lord. On 26, it will be 60 days, my lord. So during the vacation, my lord. If after vacation, then this is problem. And so I'm praying, my lord, humbly that 51 days, my lord, may be considered any terms condition, my lord.
Yes.
Yes.
Dorsey may kindly come to my lord, page number 18, my lord. Forwarding report, my lord.
Yes.
For the ground of arrest, my lord, those who may kindly see 12.34 grams, my lord, that is without soft case, my lord. 12.34.
Without suitcase.
Then my lordship may kindly come to down below, lordship. 27.54 gram with vials, my lord.
These are
Then-
not
then-
a contraband, madam.
No, what is this then?
Contraband is only.
Suspected to be heroin on measuring weight is found 27.54 grams with vials, my lord.
Yes, my lord,
Then
that.
lordship may, no, let me submit this. Then thereafter, lordship, ground number 3, my lord, 4.50 grams with vials, my lord.
That case raised under section 21B.
Definitely, my lord.
Anyway, it is not the commercial quantity, madam.
It will not come to commercial quantity, my lord,
Yes,
but
my
if
lord.
investigation,
So-
my lord, sufficient material has been collected against them. my lord.
60 days is the statute period, madam.
वो cover दिया है, वो-
Let him say.
51 days I will keep covered.
That is different aspect of the matter, my lord, but they are peddlers, my lord. I am not, my lord, exactly for the sake of objection, my lord, because there are materials, my lord, they are peddlers. He has changed his business, my lord. Earlier, he was to work in Arunachal Pradesh. Now, my lord, with his friend, my lord, he is doing this business, my lord. Even my lord, wife has also given a statement against the husband, my lord.
Against wife, what is the material?
Wife, my lord, actually, my lord, the husband was not found in his house, my lord. That is why the wife was arrested, my lord, and later on, husband also arrested, my lord. Both were arrested on the same day, my lord. And it is pending, my lord, for FSL report.
No, it's okay, but against wife, is there any, now she is also taking part in peddling of.
My lord, that is not clear, my lord, but my lord, as per the seizure is, my lord, since the husband was not present at that point of time, my lord, that is why seizure has been made from the wife, my lord. That is the materials against the wife.
But police says that you call your husband. If he come and I released him. Accordingly, she called her husband. And husband came to the police station directly. So, my lord, they are law-abiding person because no case is pending earlier of any NDPS, my lord. 51 days, my lord, maybe for the hands of justice.
After 9 days, my lord, they will be statutory period, that is different, my lord.
Yes. But 9 days left, my
But
lord.
Mr. It is 24 is for wife or
Wife, my lord, 24 is wife.
24 is wife, 48 is husband.
48 is husband?
Yes.
Heard Mr. Anuddin, the learned counsel for the 24 to লিখলো বাকি এখানে সেম থাকে no different করে লিখো আপনি property so and so বাকি so and so. It is submitted by Mr. Uddin, the learned counsel for the petitioner, that she is innocent and is no way connected in the alleged offense. On the day of incident, the police visited to the house of the accused petitioner, and in absence of her husband only, she was apprehended by the investigating officer with an assurance that she will be released on arrival of her husband. Accordingly, she made a call to her husband, and on his appearance, both the present petitioner and her husband got arrested in connection with this case. Case full stop. She is the mother of a minor child and no way connected in the alleged offense. And till that, she is behind the bar for 51 days. And considering her length of detention, she may be released on bail. She being a local person of the university will provide a genuine bailer, and there is no chance of absconding if she is analyzed on bail. Next paragraph. Mr. Borua submitted in this regard that there are sufficient materials so far collected by the IO. However, it is a fact that there is no direct allegation against the present accused petitioner, but the seizure was made in her presence from their house only, and she may take part in the drug peddling, but it is not directly evident from the materials in the case diary. Next paragraph, considering the submission made by learned counsel for both sides, materials available in the case diary, besides considering the length of detention already undergone by the present accused petitioner, I find it a fit case to endorse the present accused petitioner to go on bail for rupees so and so and so. Where it is pending?
Well, it is special just looking for.
Special just to the satisfaction of special just looking for. And now 48 of the this photo 48. 8 লিখিব বাকিখিনি লিখিব Mr. Uddin, the learned counsel for the petitioner, submitted that he is innocent and he has been falsely implicated in this case. Post. More so, the accused petitioner is behind the bar since last 51 days, and hence, considering his length of detention, he may be released on bail. Otherwise, what is his profession?
He's a cultivator.
Cultivator. He is a cultivator and maintain his family only from his cultivation work, and he is not at all involved in such kind of offenses. Next para, Mr. Burva, the learned additional PP submitted in this regard that there are sufficient intimating materials against the present accused petitioner, and the present accused petitioner is a drug peddler who is presently doing this business after, well, earlier he was staying where?
Earlier, man, he used to work in Arunachal.
Arunachal.
Now he sends his business, man, and he has started his man, drug business.
Drug peddling. Last line to Kyo. Leaving his earlier job, where he was working at Arunachal Police. The accused, the case is still under investigation, and considering the materials available in his diary, he prayed for dismissal of the present bail application for the present petition. Next para, considering the submission with the learned counsel for both sides, materials available in the case diary, wherefrom it is seen that the present accused petitioner is basically a drug peddler, and from his house, the contraband has already been recovered. Further custodial interrogation may be necessary to unearth some more facts or to nab some other culprit in this case, and accordingly, I find it not a fit case to enlarge the accused petitioner on bail at present. Hence, same rejected. Husband is rejected. Your wife is allowed.
Applies well.
In past,
Only my appearance may be recorded, otherwise.
Appearance, I don't know who took the dictation first.
25.
Right.
Made legal lordship.
Yes.
But on the earlier occasion, lordship had a query whether the petitioner, who was that person who was picked up from his house, his leg get amputed, my lord.
Oh,
Had a
yes.
query whether he was forwarded to the judicial custody or lordship had a query. So, my lord, and today, my lord, I filed an additional affidavit annexing his forwarding report, and the same thing, my lord, there was no grounds of arrest in the forwarding report also. And learned PP was also sought to, my lord, for an
And we have received a discharge certificate from the medical nurses, and also the forwarding report. And the status report is also here. I mean, now they. And not even gone to the case, also on another time.
Well, my main contention is that, madam, that the arrest memo, neither the forwarding report, there is grounds of arrest. If lordship permits, madam, I will like to place few other judgments on that issue and judgments of our honorable High Court. Yes, for foreign language, it's I don't know. I mean, 60 for some of them. My lord, here, my lord, the flag mark page, my lord, the page which have flag mark, my lord. My lord, fifth line, my lord, from clause 5. Clause 5 of the Article 22 requests that the grounds of which detention should be made available to the detainee as soon as may be. And that the earliest opportunity of making representation against the order should also be afforded to him.
in order that the detainee should have that opportunity, it is not sufficient that he has been physically delivered the means of knowledge with which is to make his representation. In order that the detainee should be in a position effectively to make his representation against the order, he should have knowledge of the grounds of detention, which are in nature of the charge against him, setting out the kinds of prejudicial acts which the authorities attributed to him. Communication in the context must therefore mean imparting into the detainee sufficient knowledge of all the grounds on which the order of detention is based. In this case, the grounds are several and are based on numerous speeches said to have been made by the appellant himself on different occasions and different dates. Then naturally, therefore, any oral translation or explanation given by the police officer serving those on the detainee would not amount to the communication of grounds. Communicating in the context must, here the oral was given orally, but that also honorable apex court, paragraph 9, the below paragraph. The Constitution has guaranteed freedom of movement throughout the territory of India and has laid detailed rules as to the arrest and detention. It has also, by way of limitation upon the freedom of personal liberty, recognized the rights of the state to legislate the preventive detention, subject to certain safeguards in favor of the detained person, as laid down in clause 4 and clause 5 of Article 22. One of those safeguards is that the detained person has the right to be communicated the grounds on which the order of detention has been made against him, in order that he may be available to make his representation against the order of detention. In our opinion, in the circumstances of this case, it has not shown that the appellant had the opportunity which the law contemplates in favor of making an effective representation against his detention. On this ground alone, we declare his detention illegal and set aside the order, my lord. So when the grounds of arrest, my lord, should be there, lordship knows, my lord. Then there is another judgment of the Honorable Apex Court, and one judgment I have given that day, my lord. Here, my lord, read your thing. That was the Constitution Bench judgment, my lord, the earlier judgment. And here also the flag mark page, my lord. Flag mark page, my lord. The para 20, the relevant portion I have, my lord, marked, my lord. It means that sufficient knowledge of the basis of constituting the grounds should be imparted effectively and fully to the detainee in writing in any language which he understands. The whole purpose of communicating the ground to the detainee is to enable him to make purposeful and effective representation. If the grounds are only verbal, explained to the detainee and nothing in writing is left with him in language which he understands, then the purpose is not served and the constitutional mandate in Article 22(5) is infringed. In any authority is needed on this point, which is so obvious from Article 22(5), reference may be made to the decision of the Honorable so-and-so state of Maharashtra and so-and-so in the state, the district magistrate. Now, para 21. Thus, all the three contentions canvassed by the counsel of the petitioner on merits were sound. The conclusion were therefore inexplainable that due to the aforesaid conversation, the constitutional imperatives, the continued detention of was illegal, my lord. Here also same thing. Then two that day I have one judgment, my lord, and recently, my lord, that was a recent judgment that they have found it. And our High Court also, from time to time, my lord, has observed, my lord, that grounds of arrest should be there in the arrest memo, my lord. Now, my lord, there is no grounds of arrest in the forwarding report also. And my lord, that apart, my lord, now, my lord, his leg got amputated. He is still under medication in the in the month of October, his leg got amputated. Now 1 month has passed, my lordship. His wounds are still fresh. So any condition, my lord, any condition, my lord, I'm praying for bail, my lord, with folded hands, my lord.
That part, Lordship, is the procedural part. I have leave it to you, Lordship, and the investigation part, Lordship, sufficient materials against the petitioner is available in the case data. Lordship has gone through already. So I have objection regarding granting the bail at this stage of only.
My lord, but the ground forwarding report also, there is no grounds of arrest, my lord. In the arrest memo also, which the lordship knows, my lord, it's a condition precedent, my lord. There should be a grounds of arrest, my lord.
Therefore, I leave it to Lordship.
And our High Court also recently, my lord, there on many occasions, my lord, lordship knows, my lord, has granted bail to the accused, my lord. As there is no grounds of arrest assigned, my lord. So if there is no grounds of arrest, my lord, his detention is illegal, my lord. And when he has a family, my lord, a small boy, my lord, 2 years of age, my lord, considering all, my lord, his, my lord, prayer maybe for bail maybe because now, my lord, it is one leg, my lord, it is impossible for him to do other things. A human being, my lord, lordship knows nature's calls are there, my lord. In jail, my lord, he's facing, my lord, lots of trouble, my lord. And his wounds are he's still under medication in jail, lordship. May see the report, my lord. Still under medication. On any stringent condition, my lord, any surety, my lord. Oblige your lordship. Oblige your lordship.
Dictation, Sharmila took the dictation this one. So most of the things will come again and then other part of the case.
Fix.
26 and the 28, my lord, maybe taken up together, my lord. Same
26, 28.
8. Same LCR, my lord. Arising out of the same, my lord. My lord, the petitioner, they were apprehended, my lord, on, my lord, 16/9/2024, my lord. And the FIR lordship will find that page 21. 3365, 365. FIR at page 21. One truck was apprehended, my lord, along with some contraband, and one person joined the days, my lord. Admittedly, my lord. And after 3 months of this apprehension, my lord, 4 months, my lord, these petitioners, they were also apprehended in connection with this case. And subsequently, my lord, the charge sheet also been filed before the court. In the charge sheet, my lord, only allegation in the entire charge sheet that the co-accused has implicated them, my lord. One joined who was in the truck, he has implicated that. That is the only material in this case, my lord. So on the basis of the co-accused statement, they are in custody. 93 days, man. So that's the only case, my lord. There's apart from my lord, there is nothing, no material, only basis of.
They are arrested on when?
Their material, they are arrested on 16/9/24, my lord. When the charge sheet was laid within the period, my lord. So only material is the co-accused statement, which is not permissible, my lordship knows the 2.6 judgment, my lord. The lordship, and there are new judgment also. I'm relying. 2.6. Only the book. List of book দিয়া আছে এখন দিকে Like kindly take up 158, my lord. 2.3.
One
Yes.
fifty-eight.
158. One 58.
Para or page?
Para.
Para.
Inner page 141.
So the confessional statement, my lord,
Hmm.
as per this, it's not admissible.
Yes.
The officers who was investigated with the powers under section 53 of the NDPS Act are police officer within the meaning of section 25 of the Evidence Act, as a result of which the confessional statement made to them would be barred under the provisions of section 25 of the Evidence Act, and it cannot be taken into account on to convict an accused under the NDPS Act. And similarly, my lord, Lordship also can take up the other judgment, my lord, 2022 SCC, my lord, 828, my lord. It's paragraph 57. On the same proposition, my lord, and considering the only material, but you can only see the last paragraph, paragraph 57. In this case, what happened, my lord? The High Court granted the bail on the basis of the co-accused statement. And the state went to the Supreme Court, and this is the observation by the Supreme Court, the paragraph 57. Although the past history of the respondent has even his conduct in relation to the process concerning the present case give rise to a few questions, but the strong countervailing factors in the present case is the prima facie indication that he is being sought to be framed by concoction and the baseless stories. Another factor noticeable is that the respondent has not been involved in any NDPS cases or any akin to offense in the past. Interestingly, the notice from the material placed on record that nothing of the contraband article has been recovered from the respondent or from any place under his exclusive control. In here also nothing has been recovered. This factor further adds on the doubt as to whether the respondent had at all been indulged in the narcotic or any contraband. That being the position, the view is taken by the High Court cannot be said to be an altogether unacceptable and impossible view in the matter. Moreover, it cannot be said that the respondent was consciously seeking an abscondence merely because he was found in the night at the so-and-so. In the case of respecting the tendency to flee has been duly taken care of in the condition imposed in the High Court. In other submission that the reference to the decision of the case, the Prasanta Kumar Sarkar Supra hardly make out the case of interference, particularly looking into the nature of the evidence sought to be adduced by the prosecution against the respondent. In this regard, it hasn't to observe that apart from the stringent condition already imposed by the High Court, it always open to the prosecution to seek imposition for a further condition, even seek cancellation of the bail granted to the respondent in case any fault on his part to due adherence to the condition already imposed. So, considering these that nothing was recovered and they were arrested after the 4 months of the incident and on the basis of the co-accused statement, because the distinguished courses here. Para 8, madam. Considering the Tufan Singh, the Supreme Court made it very clear, my lord, that in case of 439, now it is 483, my lord, the Tufan Singh is squarely covered, the bail. But in case of a 438, my lord, Tufan Singh is not covered. That is the distinction has been made, my lord, by the Supreme Court in the subsequent judgment after the Tufan Singh. This is the judgment. So in our case, we are in the already in custody. So in our case, Tufan Singh is already in covered, my lord. So in our case, the statement cannot be based for our further custody, my lord. That is the well-settled principle of law.
Oh. Yes.
Both the items.
Item There are two,
28,
26 and
20,
28.
28. Same,
They got
same.
arrested and same.
Same date, my lord, same forwarding,
forwarding.
same forwarding, my lord. Same case, my lord.
Okay.
And for both of them, there is no material apart from that co-accused who was apprehended in the car, in the trust. Nothing, no material at all.
Yes, Lordship, I have gone through the scanned copy of the case report, Lordship. Already search has been filed under section Lordship 22C, 25 and 29 of NDPS Act. That was search was filed on 31/10/2024, Lordship. And so far as recovery is concerned, that is commercial quantity for this admitted position, Lordship. Since Lordship kindly consider the gravity and nature of the offense, it's a commercial quantity. Therefore, the embargo of section 37 will come into play, Lordship. So to that extent, I'd like to rely the judgment of Union of India versus Ratan Malik 2009 to SCC, Lordship. That will be relevant because court has to put its satisfaction whether that this person will not commit any offense in future. So that is just, it's only the cognizance has been taken, Lordship. That is on Lordship 1411
We are not
2024.
disputing that part, madam,
So
the
then
regarding
therefore-
cost, not the cognizance and regarding the recovery. We are on whether on the basis of the co-accused statement. First of all, to rely on that particular judgment, they have to establish that the material has been recovered from us, first of all. The 37 embargo, when it will come, madam, there has been a prima facie material has to be there, first of all. This 37 does not come automatically, my lord. The founding fact has to be established. Where is the founding fact here, my lord? The foundation is not here itself. Where the 37 comes, my lord? 37 only come when there is a possession there, something, then the 37 comes, my lord. 37 does not come in the vacuum, my lord. There has to be some material. And what is the material against us, my lord? Only because some commercial quantity has been recovered from somebody. For everyone 37, that's not the law. There has to be some material against us, first of all, that yes, then the 37 will come, my lord. It's not automatic 37 comes, my lord, out of the thin air, my lord. That let them show that any material against us, then the embargo comes, my lord, 37.
It's a very initial stage of trial proceeding, Lordship. Only
So what,
cognizance
my lord, the
is taken.
charge has been framed, my lord, the initial stage, the investigation is complete. It's not the investigation is not complete, my lord. After the investigation, chargesheet has been laid down and there is no material against us in the chargesheet apart from the co-accused statement. We are not in the investigation stage. What he is saying, my lord, this is a nascent stage, my lord. That part is over.
Lordship, kindly consider the nature and gravity of the offense. It's an organized crime, Lordship. There might have some nexus.
I am on the
Let
law
them
point, my
relevant-
lord.
let
I am
them
on law
relevant
point.
notices examine. Let them examine, Lordship.
No, how can
There
they
are
can examine, my lord? We are on the
yes.
law point, my lord. Basically.
So Ratan Malik clearly says, in spite of not founding the contrabands from his conscious position, because court has to
Some
give-
material has to bear, my lord, that we are,
There
may
was
not be
there-
conscious, but if we, some material with the co-accused, some connection with the co-accused, abatement of conspiracy, abatement, instinct, anything, there has to be something, at least prima facie material. Some material has to be there, first of all, to rope us in the case, my lord. You cannot rope a merchant whose there is no material at all. If there is any material, I can understand 37. If there is any material, then I have to rebut that. Then only that did. And the 37 was there. Yes, there is a bar before the granting the bail. I can understand. But the fact remains that there has to be some material roping us in this particular case along with the co-accused, apart from the statement of the co-accused, my lord. Is there any material which can show that we are involved in any conspiracy? Any material to that effect? Answer is no, my lord. Regarding the conspiracy,
So for his
instigation.
It's a concern, Lordship. There are some materials against the person regarding transportation of those contraband articles along with the
Yes.
associates. Lordship.
Who
That
said
is
that?
there.
Who said? Who
The
said,
record
my lord?
says.
That lordship only says who said it, where from that connection, what is the material? Why it is not in the charge sheet? The whatever the allegation has been made in the charge sheet, there is no whisper in the charge sheet. Lordship can see the page 43 of the charge sheet, man. 41, lordship can. I don't know where from it has come from. Page 41. During the course of investigation, place of occurrence was visited and the delivery once cash so and so, and recorded this statement under 161 CRPC prepared seizure list so and so. Examining the seizure witnesses recorded on so and so. Arrested accused person Chayanta Dev, driver of the truck, recorded the interrogation statement under 161 CRPC by so and so. Re-interrogation accused Chayanta Dev and the recorded statement so and so. And the arrested accused person to the judicial custody sent CDR from the accused number and collected so and so reported was gave positive test of the so and so codeine phosphate so and so arrested co-accused Jayanta Sarkar Hussain Zakir Hussain so Mufizul Islam and recorded their interrogating statement under so prepared records eagerly so and so prepared photograph videography examined witnesses recorded statement 161 CRPC. This is the only thing. Where is our allegation? No role has been attributed to any of the co-accused here that they are involved in engaging the something, helping the accused. Something has to be there, my lord. Just out of the blue, chargesheet is absolutely silent about our role, my lord. There, or we had a culpable state of mind, my lord. That has to be also attributed that we had the knowledge. We helped with some way, my lord. There has to be some material, my lord. Only basis of the co-accused statement. To fancy is squarely covers. If there is any material to that effect, anything, then I must know what is the material concern, my lord, exact material, so that I can rebut it. There's no material, only that we have. That's why I sit silent, my lord.
So you're relying that judgment?
Yes.
And any other?
And Satpal Singh versus State of Punjab lawsuit 2018,
Do you know who lied?
13 SEC.
Give the number, we have got it.
Satpal Singh versus State of Punjab.
Two judgments she's relying. Take out it. In Satpal Singh also in summary,
Yes.
what it says? It says?
Lordship, 37 NDPS, there is a limitations on granting bail.
There is obviously.
We are not disputing, absolutely, I have no dispute about that, my lord. There is a limitation. But if before that limitation imposes, my lord, there has to be some material at least, which connect us.
Okay.
There has to be some material, apart from the co-accused statement. My case is that this is a case of co-accused statement. The chargesheet says, the forwarding report says, everything says, the co-accused statement. Nothing more than that. That's all, my lord.
You take out the judgment?
Yes, I'll give it.
Okay, sure. No, we don't need to go back to the one with the meeting. Two orders, yesterday's orders were finished. Haluk Matidu.
Item 147.
Yes, I saw him, I
He
think.
came.
So Duri was there.
He assured me that if on 20, next date on 19, if he don't come, you take adjournment. He assured me once. So let the matter then again fix on 19. If the problem is that if the matter fixed here, then it is okay. If it comes in some other court, the court will, I mean to say, not aware of this today's situation. That is the difference. So let my respectful submission, that the stand taken by them that on if 19 CD may not, if CD didn't reach. I mean,
That cannot be reflected in the order. In fact, submission was made in the morning hours. The same submission was there.
Correct.
I don't know why you're insisting on 19 because 19. I also know that it may not be possible because 19. Well, one day left. So it will be reaching the CD as well as submitting your
written
objection will be a difficult question.
They say
Okay,
that
then hopefully it may list before this bench only, but I don't know because there are lots of matters have been fixed in these days. So it may be there may be any changes.
Correct.
Anyway, let's see on 19th.
27.
Here, your lordship. Petitioner is behind bar for 41 days, your lordship. It's an application under section 483. Your lordship. Your lordship will get the FIR at page 10, Your Lordship.
Page 10. Yes.
I, Sandhya Rongpi, is it 23, residing at Pirgus in Eran, would like to file a complaint regarding harassment and unauthorized morphing of my photograph of social media and other online platforms which is sexual content and individual persons without my consent, using them to defame me, which has caused me immense emotional distress of damage my reputation. I have attached screenshots of the mocked images and messages on the materials received ID which was created in Sandhya Rongpi. Although I am unaware of that exact individual, I suspect Tonoram Charan due to previous harassment. Now this girl has some relation with me, Your Lordship, and then Your Lordship, some disputes and then this affair, Your Lordship. What is there in the case there, I don't have any knowledge, but Your Lordship, only my
He is behind the bars since
41 days, Your Lordship. Further custodial detention may not be required, Your Lordship.
As far as my lord, case there is concerned, my lord, sufficient materials collected, my lord. He varied the photographs, he moved the photograph, my lord, of the victim, my lord. Face is her, my lord, and the body is not her, my lord. By the time, my lord, he tried to, my lord, manage her in the social media, my lord. The material collected, my lord.
Then he will face the trial, Your Lordship. 41 days already.
Otherwise, it is a 60 days offense, I think.
60 days.
Yes, my lord.
Now, the way they
Lordship,
this
Lordship,
they
that
mock
is-
the photographs and all, we will be someone will be definitely.
I will not argue on merit, Your Lordship. Your Lordship, only on that point, Your Lordship, that the period of detention, Your Lordship. If Your Lordship feels that considering the period of detention and Your Lordship, custodial interrogation since investigation is complete, Your Lordship, custodial in further interrogation may not be required. Your Lordship.
Mr. S. Botako, Delaney Council Party petition. And also heard Mr. R.J. Borwa, Delaney Traditional PP Science. This is an application on sexual offense and connection with swears. CD receipt, there is the same file for accepted. It is submitted by Mr. Botako, Delaney Council Party petition. That FR was lodged only with a suspicion on the present accused petition as he had some relationship with the victim earlier.
44.
However, he has not committed any such offense as alleged in the FIR. Apart from that, the accused petitioner is behind the bar since last 41 days. And hence, considering his length of detention, he may be under strong bail. He being a local person, will provide sufficient security. And there is no chance of absconding. Mr. Nitpara, Mr. Borwa, Delaney Traditional PP submitted in this regard that there is sufficient materials against the present accused petitioners so far collected by the IO. And however, there is sufficient progress in the investigation.
The FSL report is yet to be collected.
FSL
report.
FSL report is also already collected. By
No,
the
no,
IO.
not yet to be collected.
Oh, yet to be
Yet to be
collected.
collected.
And however, the FSL report is yet to be collected by the IO. Considering the submission made by Learning Council for both sides. Materials available in the case diary. Without going further detail of the merit of the case, I found that the IO got sufficient time for custodial interrogation of the present accused petitioner. And hence I find that further custodial interrogation may not be necessary for the interest of the investigation. Where it is pending?
Yeah.
Pending is that the cases, the satisfaction has to be
CJM, Your Lordship, Kamrup.
Kamrup Metro. Satisfaction of the CGM Kamrup.
Kamrup Metro.
Yes, okay, you are allowed to go on back.
Lords.
Deeply open.
50.
50. In the first.
In this case, my lord, up-to-date record may be called. Up-to-date LCL may be called.
Charges submitted on 4/12/24.
4/12/24.
NDPS case number is 4/12/24.
NDPS 4/12/24.
NDPS case number is
Is also-
4/12/24. Lordship.
NDPS case number is also 412. And CS is also submitted on 412. Very nice. So updated may be required.
Required.
Otherwise, it was, you filed this petition before filing of the charge sheet, or?
In fact, my lord, the case was represented by another councils, who my lord withdrawn his representation. Subsequently, my lord, I engaged myself as a petitioner number 1, and petitioner number 2 already withdrawn, and he filed another bail application, and he was granted bail by a lord, interim granted.
On medical ground.
Harisharan Vishwas, he was granted bail. I am Amit Kaur. 2 persons are arrested.
Sorry, sir, because he's a blood cancer
Yes,
patient,
ma'am.
I think.
That down he was granted bail, and I am remaining. So my lord, up to date record may be called for, so the case may be contested in this one.
Case record will follow. Simply let it be. So after vacation, it will be any date, you want any date, or it will be after vacation only? After vacation. Immediately after vacation, will it report immediately after vacation?
Maybe
That
on
may it come before.
9th of January, my lord, 8th or 9th of January,
One fixed date.
fixed date. Will be better for us, my lord, so that we can prepare things.
Between 9th of January, it will be, will you scan copy we are recalling for? Scan copy of the case record we call for, updated, 9th of January. Good.
Obviously.
51.
May I please, your lordship?
Yes.
So I'm since 93 days. I'm behind our lordship. The stated period is 90 days, lordship. So I may be allowed to go on bail by default, lordship.
90 days or 180 days? I know it.
No, there is no any.
What nature of case this one is? This case nature is of?
The UAPA is there, lordship. 15 August incidents, lordship.
Then it is 180 days, I think.
Lordship, one of the co-accused has already been enlarged by one of the coordinate bench of this honorable court.
Otherwise, that I cannot say, but there was a petition filed before the learned session just for extension, in fact.
No, lordship. I have.
Actually, my lord, it was not requirement because, my lord, it's a 180 days offense, my lord.
Yes, obviously 180 days. UAP Act, isn't it?
UAPA Act, my lord.
Lordship, this honorable court has in several earlier occasions he was arrested in different cases, lordship. Similar allegations was there, lordship. He was enlarged on bail on completion of 90 days, and 90 days was treated as the statutory period, lordship.
But we have to go by the statute. In fact, how can we say that it is?
So, lordship,
Though it is a 180 days, how can we say it is 90 days? It's a 180 days offense. Obviously, there may be a period of extension also. So already in the last occasion, there is a report that investigating officer has already filed a petition before the learned session just for extension of time. In that regard, what is your report?
Is that, my lord, extension was not granted, my
lordship.
That is the, my lord.
No such petition is pending, lordship. I also gone through that, lordship.
Pending or not pending?
No pending petition is there. And I don't know whether any petition was filed or not.
My lord, my suspicion is, my lord, they have approached, my lord, but not granted, my lord.
One of
Definitely, my lord, they have filed, my lord, petition, my lord.
No, lordship, no
No, but
petition is.
one question is this, 180 will come later on, where again it can be extended up to 180 or 90 days, that you see.
My lord, 90 days, my lord. As
It
per,
is
my
90
lord,
days.
43D, my lord.
It can be extended.
It can be extended, but not.
But your extension petition is already rejected.
Not allowed, my lord.
The extension is not allowed.
Treated as a rejected, my lord.
Treated as a rejected.
Actually, as per my information, lordship, no petition was filed, lordship.
No petition was filed.
Actually, one of my colleague had got
He
to
had
the
the
report.
instruction on
Lordship,
petition.
he might be informed,
My
lordship, by the
instruction
IO,
was that,
lordship.
my lord, they will move, my lord, honorable session court, my lord, for
For
extension of time,
extension.
my lord. That is the, my lord, it was on the last date, my lord.
No, he
As submitted.
perhaps he got the information from the IO, lordship. Actually, in this case, lordship, 90 days is statutory period, lordship. And one of the co-accused has already been enlarged. I may be allowed to go on bail by default, lordship, by imposing any condition, lordship.
heard Mr. S. Ali. Then we don't go by the merits of the case at present.
Not that is done, not.
Heard
This
Mr.
period he has completed.
Yes, yes. Heard Mr. K. Ali, S. Ali, heard Mr. S. Ali, the learned counsel for the petitioner. And also heard Mr. R.J. Borga, the learned additional PP, appearing on behalf of state respondent. Case diary on earlier occasion, only case diary was received. This is an application for it order. He received, but as it was informed by the IO that, but the order, the case was fixed for today to get an information from the investigating officer as to whether any is there any extension of period of investigation for the present case. However, it is submitted by Mr. Borga that as per his instructions, the petition for extension of period of investigation was not considered by the learned trial court, learned session.
No, Paras, my lord, since they have not provided many written requests, my lord.
And what to
So,
do?
my lord, the
What can we say?
investigation, they could not complete the investigation, my lord, in 90 days. my lord.
No, in earlier order, there is a specific reflection.
My lord,
that
then-
extension.
Then, my lord, then maybe mentioned, my lord. I've been informed them, my lord, their prayer has not been acknowledged, my lord, or rejected.
That
is there.
not considered, only I have
My
said
lord, my lord.
considered. In that context, Mr. Ali submitted that the accused petitioner is behind the bar since last 93 days, and hence, considering his length of detention, he may be on last or bail. In view of above, without going into detail of the merit of the case, it is seen that the IO could not file the charge sheet within the statutory period, nor there is any extension of period of investigation till date. In view of this, bail could be bail. The voice of special judge or where?
Like this, have to go.
Learned session judge or special judge?
Special, special. Session judge, lordship.
Session, no?
Session judge.
Session judge where?
Kamrup Metro.
Kamrup Metro.
Lordship.
Session judge Kamrup Metro. Never side over a he is not so. Okay.
Deeply obliged.
The depot all upon 2 CVT depot 50,000 with 2 CVT of like amount with satisfaction of students.
52.
Yes, please, your lordship.
Yes.
This is your lordship 10 and 13 of the UAPA, your lordship, along with 308, your lordship of 3084 of UAPA, and lordship BNS. Your lordship will get the FIR at page 20.
You have received this one earlier date. No, CD is there. On the earlier occasion, there was a direction to inquire regarding the mentioning of ground of arrest or communication of ground of arrest.
Communication.
Because that plea was taken by, yes?
Communication of ground of arrest, that is not there in the city. I have sent the city lordship. But from the arrest memo and other things, that is there. But ground of arrest is not mentioned in that arrest memos.
Your lordship, so far as the present case is concerned, your lordship, I have submitted one judgment on last occasion.
Yes, this is here only. Probir Prakash.
This is also under UAPA. Section 43B1 clearly says that ground of arrest will have to be provided, and whether it is mandatory or not, that has been considered by the Honorable Apex Court and considered and interpreted. And by interpreting it, your lordship, the already Honorable Apex Court has held that ground of arrest is a mandatory requirement of providing ground of arrest is a mandatory requirement of law. That your lordship will, if your lordship again, your lordship's already gone through that part. Still, your lordship, to recapitulate the law, your lordship, para 17, your lordship, will kindly see. And in fact, this has been laid down initially in Pankaj Bansal case that was under PMLA. In Pankaj Bansal case, the Honorable Apex Court held that the ground of arrest will have to be provided. Now, whether that will be applicable in respect of other cases or not, other penal acts or not, that has been considered, and in this UAPA case, para 17, your lordship may kindly.
Para
17
of
of this judgment I have already.
Acha.
We find that the provision regarding the communication of the grounds of arrest to a person arrested contained in section 43B1 UAPA. Your lordship got it. Is verbatim the same as that in section 19(1) in PMLA. The contention advanced by the learned ASG that there are some variations in the overall provisions contained in section 19 PMLA and section 43A, 43B of UAPA would not have any impact on the statutory mandate requiring the arresting officer to inform the grounds of arrest to the person arrested under section 43B1 UAPA at the earliest, because as stated above, the requirement to communicate the grounds of arrest is the same as both statutes. As a matter of fact, both the provisions find their source in the constitutional safeguard provided under Article 22(1) of the Constitution of India, hence applying the golden rules of interpretation, the provision which lay down a very important constitutional safeguard to a person arrested on charges of committing an offence under PMLA or under the UAPA have to be uniformly construed and applied. Then para 19, your lordship will kindly 18, we can skip. Resultantly, there is no doubt in the mind of the court that any person arrested for allegation of commission of offence under the provisions of UAPA or for that matter any other offences has a fundamental and statutory right to be informed about the grounds of arrest in writing, and copy of such written grounds of arrest have to be furnished to the arrested persons as a matter of course without exception at the earliest. The purpose of informing the arrested person on the grounds of arrest is salutary and sacrosanct, inasmuch as this information would be the only effective means for the arrested persons to consult his advocate, oppose the police custody, remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental right guaranteed under Article 22(1) of the Constitution of India. Right to life and personal liberty is the most sacrosanct fundamental right guaranteed under Article 20, 21, 22 of the Constitution of India. Any attempt to encroach upon this fundamental right have been frowned upon by this court in a catena of decision decisions. In this regard, we may refer to the following observations. Then para 21, the right to be informed about grounds of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in a matter would not validate the illegality. That part is not required, but ultimately Honorable Apex Court has held that non-furnishing of ground of arrest will vitiate the arrest itself. Then your lordship, two important paragraphs are there. Your lordship will kindly see para 37, your lordship. What is to be there? What is the materials to be there in the ground of arrest, your lordship? The interpretation given by the learned single judge that the grounds of arrest was conveyed to the accused in writing by the arrest memo is unacceptable on the face of the record, because the arrest memo does not indicate the ground of arrest being incorporated in the said document. Column 9 of arrest memo, which is being reproduced herein below, simply sets out the reason for arrest, which are formal in nature and can be generally attributed to any persons arrested on accusation of an offence, whereas the grounds of arrest would be personal in nature and specific to the person arrested. Now, your lordship, if your lordship sees the forwarding report, these are the general grounds of arrest, even in forwarding report, not furnished to me, your lordship, not specific to any of the accused persons. 3 accused persons are arrested, your lordship, that is not there. Then reasons of arrest has been mentioned. Then your lordship may kindly come to para 48, last paragraph, your lordship. It may be reiterated at the cost of repetitions that there is a significant difference in the phrases of reasons of arrest and grounds of arrest. The reasons of arrest, as indicated in the arrest memo, are purely formal parameter to prevent the accused from committing further offence, for proper investigation of the offence, to prevent the accused person from causing evidence of the offences to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any persons acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons should commonly apply to any person arrested on charge of the crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested so as to provide him an opportunity to defending himself against custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest, which are generally in nature.
You want which para?
Your Lordship, para 48.
48.
Now, going by this, Your Lordship, this arrest itself is vitiated, and in the meanwhile, Your Lordship, he is in custody for 85 days, Your Lordship, at the end of the day, Your Lordship. And Your Lordship will find that he was an employee, Your Lordship, working in the North Lakhimpur College. And his name is in fact not there in the FIR, and the phone number that is not there, that is there in the FIR is not belong to him. And there are 2 or 3 others. What specific role he has, that is not described either by the forwarding report or ground of arrest, since not have been provided to me. I am not, it is not known to me. I am not privy to the materials available in the case diary. But keeping in view all these factors, Your Lordship may impose stringent condition, Your Lordship, young man, Your Lordship. In fact, except probably some phone records, Your Lordship, at some point of time of youth, Your Lordship, always there is a tendency to be radical, Your Lordship. More than that, probably this boy has nothing to do with all these things, Your Lordship. Keeping in all these factors, Your Lordship, I pray before this Honorable Court, he may be released on bail, more particularly when the arrest itself, as per the dictum of the Honorable Apex Court, is vitiated, Your Lordship. He can be in stringent conditions may be imposed by this Honorable Court. He is not a flight risk, Your Lordship, not even have passport. His family has a very good background, Your Lordship. The father was an officer of the state government, Your Lordship. He will abide by any conditions imposed by this Honorable Court, Your Lordship.
Yes.
So I have
Notice you have stated.
47 BNSS notice has been served, but yes, Lordship, that the grounds of arrest is not mentioned there, Lordship, and that is true, Lordship. But apart from that, Lordship, sufficient materials are there, Lordship. He has also stated that he is in connection with that group, Lordship. And that is there, Lordship. His statement is there.
Whether he was earlier in Alpha and all?
Lordship, he is not, but he is not in contact with them, Lordship. He is the contact person earlier. He is in contact with them. It is there. Statement is there, Lordship.
And since he has admitted, Your Lordship, that means he has cooperated, Your Lordship, with the investigation also, Your Lordship.
Apart from furnishing the ground of arrest, Lordship, everything is there, Lordship, against him, Lordship. But that is not there. It is true.
Stringent condition, Your Lordship, young boy, Your Lordship, may impose, Your Lordship. He will abide by that, Your Lordship. In every week, if necessary, he will appear before the police, Your Lordship.
I'll speak to his diary also or something. How many matters left, no? Is it of October or left? How many? Oh, APR.
Matter relates to Jimma of Eran Lordship. On the other day, Your Lordship has seen that I have submitted before Lordship that the truck which was loaded with Eran nuts was sent by the petitioner to West Bengal, and it was parked at the place of occurrence because Lordship, they could not collect the UA bills and pay the GST. And therefore, Lordship, it was parked. And police said, Lordship, it was placed at abandoned place. It was not abandoned place. On that day, due to server problem, Lordship, they could not submit. And in connection with that, Lordship, I have shown for your Lordship the challan, which was which is at page 19. Page 19, Lordship, may kindly see.
Yes.
This is the challan. Down below, your lordship will find signature of the petitioner, and it was sent to top person lordship named Sanjit Ghosh, West Bengal. And on the earliest date of occurrence, it was the vehicle was parked. It could not cross the border because lordship they have not paid the GST admitted on that day. And immediately on next day, lordship, her husband went to submit the GST, and he was apprehended along with that. And thereafter, the present FIR was lodged. And lordship will kindly see that after that incident, lordship they tried to submit those documents before the investigating officer, but he did not receive any documents from her lordship. And therefore, lordship, finding no alternative, she had to send all those documents through mail, lordship, through by post, lordship. That your lordship will find page 20. And even if your lordship see the report which was submitted by the investigating officer before the police, that your lordship will find page 25, impugn order. There is nothing mentioned that these the documents which were submitted by the petitioners are false or these are not genuine. That aspect is not there. And what I find for
It is a rejection order.
in the rejection order itself, your lordship will find. And what I find, lordship, that mainly these are my prayer was rejected on the ground that the report says, FSL report says that these are not fit for human consumption. That your lordship will find page 26, last portion. And in this regard, lordship, my submission for lordship that SOP which I have enclosed at page 28, it says, lordship, that if it is not human consumption, then lordship, then one undertaking has to be given to the SP. That your lordship will find at page 31. That relevant page 30, lordship, I'm sorry, page 30, serial number 15. I'm sorry. May I read, lordship? Down below your lordship will find it may happen that even if the seizures use unfit for human consumption, there may be a owner or a claimant owner or claimant, two things are there, lordship. Claimant who may submit a plea before the court that they would such betel nuts as raw material for manufacture of some non-edible produces, and the same will not be used for human consumption. In that case, Superintendent of Police should got the claim verified and report to the court. So it is duty of the Superintendent of Lordship of that concerned district to verify the same and submit it to the court. But if your Lordship see kindly the impugn order, that relevant portion at page 26. Last 3 lines, lordship. Further, it appears from the food analysis report that the seized areca nuts are not fit for human consumption. And in this regard, the Jimma petitioner also failed to assure this court that in case the Jimma of the seized areca nuts is granted to the petitioner, then the petitioner shall use the same only for the purpose of industrial use and not for human consumption. So first, it has to give Jimma. Thereafter, I will submit a report undertaking before the SP, and he will inform the court, lordship. That is the procedure. And if on the other day also I have submitted 2 judgments of our High Court, lordship, where it is that first case was that customs reference case. Last part says, lordship, that if it is not for human consumption, lordship, and after that if it is used for human consumption, some other provisions will come, lordship. Other provisions will come. So other subsequent FIR has to be registered. In this proceeding, that cannot be, lordship. And lordship, that another I have given that writ appeal 30619 Samseruddin. Here also it is said that if it is they say that it is Burmese super, then the matter has to be sent to customs. The police have no jurisdiction to investigate those aspects. And if this did not, in the present case, they already concluded the investigation, submitted charge sheet. So it shows that these are not Burmese superheroes. These are local businesses also. They have collected from various villages. I have stated in my paragraph 4, Lordship, all the details, Lordship. Paragraph 4, page 5. And another one, judgment order of our High Court, Lordship, I am submitting. Here also similar direction was given to submit undertaking before the SP considering the SOP, Lordship. Lordship, may kindly see paragraph 11, Lordship. May I read it?
Yes.
Thereby, the impugn order dated 22/2023 relating only to rejection of the prayer of Jimma of the seized Eran nuts to the custody of the petitioner is set aside. The petitioner is at liberty to submit a petition before the jurisdictional court with prayer for Jimma of the seized Eran nuts with an undertaking that the seized Eran nuts will not be used for human consumption, and the learned magistrate may pass an order directing the SP to consider the Jimma of the seized Eran nuts as per SOP for disposal of seized betel nuts, white so. That probably, if that direction is given, then SP will verify my undertaking, Lordship. And admittedly, there was no.
Before the petition for magistrate, should you, the undertaking has to be before the SP or after, as per SOP, what is the
As per SOP, before the SP.
Before SP first.
Before SP. He will verify and report it to the concerned magistrate. That again, I am referring to that, Lordship, page 30, serial number 50. I can submit it before the concerned magistrate and it may be verified through the superintendent, Lordship.
My learned friend has prayed for this Lordship. Made any prayer before the SP, Lordship? Because without making any prayer before the SP office, how can it be verified? So earlier occasion, the prayer, as I could remember, his person was totally different. It was report was called for by this honorable court regarding the prayer status report, whether, Lordship, those says articles are used for, if it is not used for human consumption, then it will be used for industrial purpose. For that purpose, whether he have filed any prayer before the officer in concert, that is SP office.
Because I cannot submit prior.
If it is so, then he has to show us the letter, because a report was called for to that regard. So accordingly, I have provided the report, have given to court master. The status report is before Lordship perhaps.
No, you want to submit that whether he has suffered.
Before the SP office, that it is not fit for human consumption. So I want to use it for industrial purpose, whether he has made any prayer before. Then only the office will be verified. Office would verify the report, and thereafter necessary action will be taken by the concerned officer, whether he has made any prayer.
No, he has not made any prayer.
If it is so, then he has to show us a letter, Lordship.
So just one thing, if I may
Lordship,
point out.
go through the status report, then Lordship will come to know.
Just one thing, if I may, Lordship, when I will file Jimma petition, Lordship, a report is normally called from the concerned IO. We do not know what is there in the report because food analysis report is not supplied to us. If it is against us, then we may be given a chance that it is against food analysis report said that it is not fit for human consumption. Will you submit any undertaking? That opportunity has to be given to us. That was not given. That is why I am placing for Lordship that we will file a fresh application with that undertaking that we will not use it for human consumption. And the court will verify it through the SP. That is my humble prayer.
I've got no objection to that report. But earlier it was something else.
Here again, the report says that during investigation, the petitioner or the seized of the seized Eran nuts has not neither submitted any document of sale Eran nuts or the industrial purpose. These are things that you have not submitted before the IO.
Yes.
Till now.
Document, that is why I have placed before your
Regarding your
lordship
claim, the
that-
ownership.
Yes, your ownership,
Yes.
that is claim. Regarding undertaking that, I will submit freshly, lordship, because I was not aware that this report has come.
It is it's a non-edible one.
Not edible. That report has come, I was not aware. So I will submit an undertaking that will be verified.
I have got no objection to that.
Heard Mr. Eran, the learned counsel for the petition, and also heard Ms. S.H. Bharat, the learned additional PP appearing on behalf of state respondent. This is an application under section 528 BNSS against the impugn order dated 18/9/2024 passed by learned GMFC Dhubri, whereby the Jimma prayer of the present petitioner was rejected. And prayer for auction was also allowed by
Yes,
that time.
oh, no, by that time. That order was stayed by this honorable court.
Allowed the prayer of investigating officer for auction sale of the seized Eran nuts. But as per your report, whether there is any process initiated for the auction? No.
It is not yet, lordship.
Not yet.
Yes.
Post up so and so. Report received, next prayer, report received from the investigating officer. Where is the same? Next prayer, Mr. Ahmed submitted in this regard that the present petitioner is the owner of the seized Eran nuts, which was duly purchased by him. From where you have purchased?
Local markets.
Local market.
Local market. And thereafter it was sent to one Somjit, supposed to be sent to one Somjit Ghosh.
Who is the Hia Enterprise? You are the Hia
I am the
proprietor.
Yes.
And he is the proprietor of one Hia Enterprise, having valid GST registration and all other relevant documents. But on the day of incident, and all these seized Eran nuts were purchased by the petitioner from the local market. However, you don't have any e-way challan bill you could not furnish, or it was, what was your submission?
It was supposed to be obtained on 28th, but on the same day, her husband, along with all the papers, he was arrested. Therefore, he could not submit the GST bill on 28th. It was sold on 27th, and there was due to technical defect, there was server problem was there. Therefore, they could not procure the document on 27th. On 28th, he went to the office, and in between, he was apprehended, her husband.
And the petitioner is a wife of the
petitioner is petitioner is the proprietor. Her husband was arrested, who went to submit the GST.
Now she is claiming this one.
She is claiming, lordship.
But on the day of incident, due to some technical error, her husband could not collect the GST bill, and accordingly, prior to the collection of the GST bill, her husband was arrested in connection with this case. The truck was seized. Truck was it was parked in the roadside, no?
Parked in the roadside.
Truck was seized when it was parked in the roadside, and the driver was to collect the e-way bills. E-way bill was collected for collection. However, the present petitioner is the genuine owner of the seized Eran nuts, and accordingly, claiming her ownership, she filed a petition before the learned trial court below, seeking Jimma of the seized Eran nuts, and the same. However, the prayer for Jimma was rejected by the learned trial court below, only on the ground that the seized Eran nuts are not fit for human consumption as per the report of the FSL. The order is a page.
Imperial order, your lordship, on page 25, starts from page 25.
At food analyst report, sorry, FSL, food analyst report, the seized Eran nuts were not fit for human consumption, and the petitioner failed to issue the court that in case of Jimma of the seized Arakanas is granted, the petitioner shall not use it for human consumption and will be used for industrial purpose only. First, but industrial purpose only. First, but the petitioner was never give any chance for production of any undertaking before the learned trial court below, which is required as per SOP from clause number 15. More so, the petitioner was not aware about the fact that the products were not fit for human consumption as per the report of the food analyst. However, at present, he is ready to file an undertaking before the learned trial court below, and if the so that it can be verified through the SP regarding the genuineness of the claim. Genuineness of the claim as required under the clause 15 of the said SOP. Next para, MSSH para submitted in this regard that as per report of the investigating officer, the petitioner could not produce any document of sale of Arakanas for industrial purpose, nor there is not collected any approval order from the SP office. Further, however, it is submitted that till date there is no auction process is initiated. MS Bora further submitted that if the petitioner files fresh application before the learned trial court below, with an undertaking, the state has no objection if same is verified by the SP concerned. Next para. Considering the entire submission made by learned counsel for both sides, the made facts the other aspects of the case. It is seen that by the impound order dated 18/9/2024, the prayer for 18/9/24, the prayer for Jimma was rejected only on the ground that the Arakanas are not fit for human consumption, and in the same time, it was not verified. The claim was not verified by the SP as required under the SOP. In view of this, the impound order dated. No. However, from the production of the documents, regarding the claim of ownership, is there any observation?
No adverse report is there. Although I have submitted this through, I have sent it to by post also.
More so, the petitioner has submitted some relevant documents to prove the ownership of the seized Arakanas, full stop. In next para, in view of this, the impound order dated 18/9/2024 is hereby set aside and quashed, and the petitioner is at liberty to file a fresh application for bail seeking Jimma of the seeking a fresh application seeking Jimma of the seized Arakanas, and the learned court below will accordingly with an undertaking that these Arakanas, which are not fit for human consumption, will only be used for industrial purpose and will not be used for any human consumption. We did on furnishing such undertaking, the learned trial court below will accordingly verify the claim through SP or through office of the concerned SP, and will pass the Jimma order accordingly as part of obligated. SOP যেটো number আছে, number টো ইয়াতে আছে, মই দি দিম পিছত আপুনি লগাই ল'ব লম্বা নম্বৰ এটা আছে SOP নম্বৰটো যিটো ক্লজ 15 আমি ৰিলাই কৰি আছো ঠিক আছে বা আপুনি দিব পাৰে এটা মাজত নালাগিছো নালাগে with the above observation the present petition stands disposed of. Okay, we discuss.
So yeah, in order in respect of Jimma and Oxon, that may be mentioned because on the same day, cognizance was also taken.
Jimma in respect of the order লিখিছো the order of line the set aside and post আছে যে in respect of past in respect of Jimma and Oxon.
Status report.
Jimma and Oxon. So আগতে লগাই দিব.
That should be kept as a part of the record.
Yes, status report filed by the investigating officer be kept as a part of the record.
Okay.
So that 15 and 17, I was not there. Can it be taken up day after tomorrow, Lordship? I can remember 15 and 17. If it was called, I was not.
May not be possible day after tomorrow. We'll see to it.
Only for listing, also if it does not reach, we will not object to that. Because already he is custody for more than 2 years, 3 months. Lordship. Only if it is listed for that purpose only. Day after tomorrow.
Order has already been passed, I think.
Only that
We'll
date.
see to it if it can be. Pune listens petition by you only? No. 15 and 17? Okay, we'll see to it.
29 for bail hearing.
Please, your lordship. Firstly, in this case, lordship, initially the petitioner was granted interim bail, lordship, and he appeared with the IO, and his statement already been recorded, lordship.
Lordship, I think 29 and 30 both are same. Out of
29
6,
and 30. You're appearing with both the matters?
No, I am for 29 only.
You're for the 29 only. 30
Then,
30
lordship,
will
here
appear.
in this case, we have a pair, lordship. He is on both these petitioners are on interim, lordship. So we couldn't go through the entire record, lordship. Can it be after application, lordship? Yeah.
But in that case, you are retaining the case diary. You want to retain the case diary?
Lordship.
Then in that case, one date has to be fixed.
Immediately after application, lordship.
After the evaluation, lordship.
After Bihu retaining of case diary so long will be difficult on our part.
Immediately after reappointment. On third or sixth, lordship.
Third may not be.
Sixth,
Third.
lordship. Sixth.
In the this case diary will be sent back. Because whatever, because of the transfer of the IO, one or two IO has been transferred. I have appeared thrice time, but it has not been reflected because CD is here.
Oh, watch it. Okay, in that case, you return.
Kindly,
the
my
case diary. After Bihu vacation, then you will be fixed. After Bihu vacation and date. 29. 29-1. Both 29 and 30 hard আপনি বেলেগ বেলেগকে দিব matters are different এটাত first আছে Mr. F. Hawk and the second one is Mr. S.C. Biswas is there. Okay, so both the matters are there at the request made by the learned additional PP. Matter is adjourned. List after or not list on 29-1-2025. CDP return accordingly, calling for the updated one. And till next date of listing, the petitioner will the interim order shall be extended till next date of listing. Voting matters.
For admission item 8.
Yeah, please, your lordship. Madam, this is the admission matter, madam.
Yes.
So I think I have checked it, my junior madam. The scan copy has not been called for. So
Not been called for.
yes, madam. So I believe that it may be called for and a date of hearing may kindly be fixed, madam. It will be required, I believe. ma'am.
Inadvertently, it was not called for, I think.
Yes.
Oh, no. Oh, the stay order was there, but
Scan copy was not.
scan copy was not called.
Along with that case diary, assuming.
Is he
Yeah.
Respond number 2 is already appeared. You have already appeared.
Yes, madam.
Out of station.
Whatever you appear.
The appearance is complete, madam.
Mr. Jepkama, the learned senior advocate, assisted by Mr.
Eran.
M. Ahmed, the learned counsel for the petitioner. Also heard Mr. B.S. Lohko, the learned additional VP for the state respondent, and you are Mr. A. Khalik. You for appearing for A.Z. Ahmed. Appearing on behalf of Mr. A.Z. Ahmed for the respondent number 2. It is submitted by Mr. Kamal that inadvertently the scan copy of the LC was not called for. That is court. That is court. On perusal of the record, it reveals that the scan copy was not yet called for accordingly. And it is submitted that scan copy may be required for the disposal of this case. Scan copy, yes, record number is what is?
PRC case number.
PRC case number?
I'm giving one.
2701-2020.
2701, yes.
2022.
Of 22.
Pending before which court?
Learned JM Judicial University Fast Class Dhubri.
Learned JMFC Dhubri.
Dhubri or Golabganj?
Dhubri.
Accordingly, call for the case record of PRC 2701 of 2022 pending before the learned JMFC Dhubri. The registry will do the needful. It will be obviously after vacation only. It did not.
One good thing will happen, my lord, if it is listed on receipt of date. Otherwise, again, it will come and go, my lord. We'll have to wait for the whole year.
In date, long date.
No, I'm saying that if it comes on the stop
Okay,
date
list
also,
the matter immediately.
after receipt of the scan.
On receipt of the scan copy.
That will do. Much.
Interim was there.
Stay back, I think.
Interim becomes extended till next.
So otherwise, again, it will come, it will not come again. So when it will be coming, my lord, then it will be listed automatically. Then we'll argue the matter. So my lord, my interim stay will continue, my lord.
Yes, it will be done.
That's done. Much okay.
Item 9.
Interim continue.
Well, please, Your Lordship. In item number 9, Lordship, I have been informed by learned Americas that she could not come today because of a personal difficulty, Lordship.
One MSP does was there.
P does. Correspondent number 2.
Yesterday also in one matter, she was probably.
Probably she is not well, so she could not
Oh.
come. Lordship may fix this matter after vacation. A date may be fixed. This matter perhaps will take some time. The allegation is regarding false promise of marriage, and we have sought for quashing of the entire procedure. So Your Lordship may fix it on a Thursday or on any hearing date.
Hearing date?
Yes, on Thursday or Tuesday.
Or Mr. R. Bharat, the learned counsel for the petition. Also heard Mr. B.S. Lawford, the learned additional VP for the state respondent number 1. MSP does the learned amicus curiae representing the respondent number 2 is absent, and it is informed by Mr. Bora that she verbally intimidated him to take an adjournment. This matter according you want Thursday, Tuesday, Thursday, any day. 13 February will do, or
Can it be on January, Lordship? Immediately after the Bihu vacation? On 23rd.
Tuesday or Thursday, 20.
On 23rd. If it is possible.
23rd, in fact, there's only 1 week again. Then it is full. Better to take on 11th of February. This is Tuesday only.
Not. Obliged.
11th February. Well, there's no, I think.
No interim order.
List on 11th February. Yes.
Item 10.
One moment, please. 12. Item 10. Item 10. None appears on call for the petition. Heard Mr. B.S. Buffer for the Land Council for the state respondent. Placed the matter according to application.
Please, your lordship, the matter will be possible for the time being. Lordship, I'm appearing for respondent number 2. As the scanned copy of the LCR reports have already been received, so matter may be fixed for hearing and the petition copy may be served upon us. Okay,
Copy is not yet served.
not yet received, Lordship. Okay.
Otherwise, case is ready for hearing.
LCR for records received, no? LCR
Want
records never
to
been
want to
received.
get it fixed, I mean, want to fix it in for hearing or admission?
For admission hearing, it will be for admission.
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 In fact, it was already for admission hearing, but you want to get the copy, in fact. Copy is not provided
Not
to you.
provided.
You have heard, you are MS?
Yes, Pradhani.
Heard MS A.S. Pradhani appearing on behalf of Mr. H.R. Chaudhary. H.R. Chaudhary, the counsel for the petitioner. And also heard Mr. B.S. Walker, the learned counsel for the state respondent. And MS.
A. Bora.
A. Bora for the respondent number 2. It is submitted by Ms. Bora. That copy of the petition is not yet provided to her. Accordingly, the petitioner is hereby asked to provide the copy of the petition. Today, you can be able to provide the copy
Tomorrow you
within the okay, provide the case copy of the case petition will be put to you. Scanned copy of the answer has already been received. List the matter accordingly after vacation. Immediately after vacation, we'll do.
Yes, Lordship. Date will be fixed, your Lordship.
Date is problematic for us. Date, if you want to insist on that, then it will go a bit.
Then after Bihu vacation, no issues regarding that.
They may have any urgency, yes.
Okay.
After vacation, after Bihu.
Okay.
After Bihu corridor Saturday. They're insisting for date. Immediately after vacation, then we'll give it. If you believe it after vacation.
My lord, this matter is very urgent, my lord. In this regard, my humble submission, my lord.
No, they are seeking time because copy was not provided to her. In fact.
Brief for the fact.
My lord, copy, we have taken steps.
No, that
We
I
have
don't
taken
have
steps,
to,
my
I
lord.
don't
It
know,
is-
at present I cannot say.
It is their fault, my lord, how they may lost the copy, my. We have taken steps on that. So my humble.
And along with the notice, you have already sent the copy.
Yes, my lord. Already sent.
Then it may be misplaced, I don't know.
So, anyway, my lord, I will again serve a copy. My humble submission in this regard, if I go to the merit of this case, I mean unnecessarily, my lord, just to my lord, complete the investigation, the police made me as a scapegoat and filed the charge sheet. And
Against
I
you
am
only or other accused are also there?
other accused there, but only in my name, the charge sheet is filed, making me
You are the only charge sheeted accused.
only charge sheet. However, my lord, the case was not filed against me. And I am a married woman with young kid, only 22 years of old woman, my lord. And even
Okay, now she is praying for a date after Bihu. So
Okay.
you want prior Bihu?
This is not my difficulties. My humble submission on the first day, my lord, after hearing the in motion days, after hearing this matter, my lord, this honorable court told me that interim will be granted, one returning will take. This is the order on the first day, my lord.
Now,
So
so
if
we
you-
are not in a position to grant any interest.
So, my lord, if your lordships grant interim, my lord, otherwise, my lord, I am facing very much difficulties. And unnecessarily a case is
No,
made.
interim will not be there. You are the only charge sheet accused. First day, if interim is not there, not there. We cannot still help.
First day, my lord, it was
Before Bihu, did you? Before Bihu? When did
Before
decide it? Before Bihu? 10th. On 10th.
10. Obliged.
Much obliged, Lordship.
Okay.
Okay, that's it.
I said 49.
49. Answer registered, it is similar. The same. No, one is unserved, return unserved, and number 2. The service report. No, for only these 2 reports are for only for 2 only.
Yes, responding to.
Respondent number 2. One is state, I think. One is state. None appears on call for the petition. By Mr. B.S. Kalkot, Eran additional PP. For the state respondent. From the office note dated 22/11/2024, it reveals that the notice returned unserved on the respondent number 2, which was sent through registered AD. However, the service report is still awaited from district magistrate Kokrajhar. This is the matter accordingly after vacation.
For orders, item 32.
Services. Services.
I think it proximate case is the LOC. This is a proximate case LOC and notice not served LOC.
Lordship, as per the last order dated 19/11/24, direction was made to take the fresh step. Accordingly, we have taken the steps. And as per the delivery report, so it has got delivered.
Delivery report of postal or what?
Yes, yes.
Appointed.
In that case, amicus will be appointed. Otherwise, also it is a case of what nature? POXO only.
POXO.
But the steps were not sent through that process. Through judicial police station, you have not sent.
Earlier,
was
the
not.
attempt was made like that, but after that, it was sent through postal Talabana.
Acha. Now we have furnished the postal receipt, postal acknowledgement and all.
Acknowledgement, and that is the delivery report that postal
Postal report.
is there.
Is there any other postal report here? Guwahati High Court for service of notice and respond number 2 on or before. Okay, What are saying it is? This is the order 2/8. Wait, what order is through? You are submitting on order dated which order?
19/11/24 last
order.
Last order.
Last order is 29/11.
Sorry, it was on, yes, it is 29/11.
29/11.
So then again, steps were taken on 30th/11/24.
Okay.
Notice was issued on 3/12 issue. First steps were received and registry issued notice on 3/12. It has gone directly by registered post.
Once I've noticed.
Not through the receipt.
What she thoughts are some key answers.
As per the Deepak Naik case lordship, this is not the proper way.
This is the track consignment report only.
Yes.
But the doesn't see whether it is judgment delivered or not. But it's a POXO matter. Should we go in that manner? That would be better, I think. She again took the steps to register AD only, not through the judicial police station. Then what to say? It will with regard to
As per the one of the Deepak Naik case lordship, he has to go through the office of the PP. Then
yes,
to
obviously.
or
That
SC
manner you have
consult.
already taken steps. We don't have find anything here. That's why I'm just asking you. Answer only you have sent through AD only. I mean registered AD through postal. But whether you have taken any steps through the jurisdictional police station or through the office of the registry and the public prosecutor, is there any process you have taken steps? Because nowadays it has to be, or otherwise, if it can be deemed to be served, then amicus has to be appointed. But nowadays has to be gone through in that manner only. That's why. But however, it is an appeal. Let the amicus be appointed.
Consider it as paid as well, we will process it.
Your petitioner is behind the bar or he is outside?
Behind.
Huh?
Behind the bar.
Behind the bar. Item number somebody ইয়াৰ পৰা একো ধৰিব পৰা নাই কেনেকে গম পাম?
She had, I think, collected from the post office.
No, no, it says that state consignment reporting
Track
হয়.
consignment,
Item number লগত সেই pin code সেইটো মিলাব লাগিব নহলে কেনেকে জানি কোনটো itemৰ against কোনটো?
Registry should.
Registry should verify in fact. Because we don't have the receipt from whom it has to be matched with. Because there is a consignment, actually one number is there. That has to be tally with that other one. Otherwise, seeing only this one computerized copy, we cannot say that item, whether that item has been delivered or not. It's better to take steps, I think. Because from here, it will not be possible, in fact. We know we don't have the things also, the receipt also. Where from the number, the number has to be tallied with the other one. Yes.
In that receipt, there is a number.
Yes, number from the there only there can be tracked. Otherwise, we are insisting because it is a POXO. Otherwise, it's okay. Otherwise, then 302 and all, it's okay. But it's a POXO matter, so the victim should be represented by someone, in fact. If not possible, then definitely we'll appoint an amicus. It's an appeal of 2021, so already delayed. This time you take one step, and in that case, the additional PP or the prosecution will have the opportunity to inquire as to whether this concerned police station had received the notice, whether it is delivered or not. This kind of information we can get from the additional PP or PP.
Police station or the police about to.
Hard MS.
Then again, also there is that step has been taken to the OC concern. But whether they are, even though the OC concern has received that articles, whether it is served or not, that has to come. Because they are
So
not.
it is already that steps most probably taken in the year 2021. So presently it may not be in a position for you to inquire the matter in regards to service. Otherwise it's okay, but it's not here. You are MS?
M. Sharma.
Hard MS M. Sharma, the learning counsel for the appellant. Also hard MS Mr. B.S. Lockford, the learned additional PP so and so. Office note dated 12/12/2024 speaks that no unserved notice, neither the unserved notice nor AD card has been received by the concerned section. However, it is submitted by MS Sharma that as per the track consignment report, the item is already delivered. But at this stage, it is not possible for the court to verify regarding the service of notice or the track consignment report. Accordingly, it is as the matter relates to POXO, the appellant is hereby directed to take fresh steps on the respond number 2 through jurisdictional police station, routed through the office of the registry and public prosecutor. The public prosecutor will accordingly make verification. List accordingly after vacation. You take one step again. This has to go, just understanding the procedure. One has to go to jurisdictional police station, but it has to rotate to the office of the public prosecutor. Registry first. Registry will then again send it to public prosecutor. From public prosecutor, it will go to office of the, concerned police station. And then it will be easier for the prosecution to inquire about the service of notice. Okay, we are listing it immediately after vacation. You take steps within 2-3 days. After vacation.
Obliged.
33.
May I please, your lordship? This criminal IA, my lord, IA is for condonation of delay, my lord.
What was the delay?
My lord,
124 days.
Yes, my lord. It is-
Why?
And it is explained, my lord, in page number, in page number, 3, page number 3, paragraph number 3. That the petitioner begs to state that the impugned order is not cast out by the petitioner advocate on 10/5/2023 or its subsequent dates in spite of asking of the petitioner's advocate to the bench assistant. Several times, the advocate of the petitioner went to the dealing assistant of the court to know about the order, but the same said that it is not in the record because it is not written by the learned magistrate. But the case is fixed after long more than 2.5 months, that is 1/8/2023 for evidence. Then the petitioner begs to submit that advocate went to query about the impugned order on 1/8/2023. Surprisingly, the order is not sheet in the case record by his advocate. Till that, the order is not enclosed with the case record. But the case is fixed on 3/11/2023 for evidence. Thereafter, after 1 day not fixed by that, before puja vacation. the
But just
advocate-
Mr. Sultana, Ms. Sultana, just a second. As per order dated 27/5/2024, there was a direction from the court that name of the father of the applicant, I think name of the father of the respondent, but
Yes, my lord.
has been wrongly mentioned in the petition for
Yes.
which she has brought some time for additional affidavit. Have you filed any additional affidavit today regarding the correction of the name, in fact?
My lord, this is disposed, my lord, IA. It is correction of the name of the.
It is already disposed of.
Is this disposed, my lord?
Okay, it is already disposed of. Huh? Or that petition has already been disposed of.
Yes.
Okay. It's not any, there's no any reflection. That's why I'm
Thereafter, thereafter fresh step is taken, my lord, to the respondent, my lord. Before correction, step is taken by postal talabana and ordinary post, my lord. Thereafter, in the record, it is seen that the service is not done as due to the improper, as the address is not proper, my lord. Thereafter, the record is cast out that one mistake is committed, type mistake, that is the father's name, respondent's father's name is wrongly mentioned. Thereafter, advocate paid for the correction, then IA is filed, and in the direction it was directed, and there it is rectified, my lord. And that
now
IA
what is now here it is Nikunjam Medhi, son of Bonamali Medhi. It is
Yes,
not correct.
Bonomali, it is Bonomali Methi, my lord.
It is correct.
Yes, my lord.
Earlier it was not Bonamali.
Earlier, it was by mistake, it was typed as a Gopal Methi, my lord.
Now it is correct.
It is correct, my lord. Thereafter, after correction, my lord, Nikunja Medhi, notice is served to the Nikunja Medhi, that is respondent, by post, by registered post, my lord. And I do not know what is the report in this case, my lord, from the respondent side, my lord. But it may be served, my lord. It is second step is second on 11/12/20.
11/12.
Yes, 11.
You have taken steps on 11/12.
Yes,
Yes,
my-
yes,
yes, my
going
lord.
on.
Step second, my lord, is
Yeah, take
registered
note,
step second to the register on 30/10/2024, my
নাই
lord.
কোনটো কেছৰ লৈছে?
30/10/2024.
মেইন কেছটো ৰেজিষ্টাৰে হোৱা নাই। Too high.
Yes.
She's saying 10 October. The correction was when it was correction was made? No, because there is no note in fact in the registry.
It is correction by order dated 16/9/2024.
16/9.
Yes.
And
ma'am.
thereafter you have taken steps on October, that is on
Yes,
10.
ma'am, yes.
There's no reflection at all. That's why just I'm asking you. The correction was made on 16/9, exactly, right?
Yes.
And thereafter you have again
Again, steps taken
steps taken
on 30/10/24, my lord. This
why there is no reflection at all. In fact, who does? State receivable. Go to 9. Bringing that steps up into the. It's not reflecting in office. Now, online is also showing that you have taken steps. It's not note from the registry, in fact. That is the problem. We are not having any note from the registry because one formalities has to be observed.
Yes, ma'am.
If it comes written after, even after unservice or 124-day delay of hearing the prosecution side, it may be disposed of. I'm not on that. But the question is, at least after correction, because one order is here, one notice has to go, and as rightly submitted that on 30/10/2003, you have already taken steps. Online is also showing. We want to just verify it from the registry, otherwise, because office note is not there. That is the problem.
There has to be office note of it.
Has to be there in the office. Hard MS. VRA Sultana, Internet. You are not an MI legal aid, na?
This is not a legal.
You are appearing
Personal
for
case,
personal.
ma'am.
And so, for the appellant, oblique applicant, and also hard MS SH Boda, Internet Council for the state respondent. It is submitted by MS Sultana that in pursuant to order dated 27/5/2024, there was a correction of the name of the father of the respondent number 2, and accordingly the steps was also taken in the correct address of the respondent number 2. She also produced one acknowledgement card before this court, wherefrom it is seen that the steps was taken on the respondent number 2 on 30/10/2024 after correction of the name and address. However, there is no office note in regards to the receipt of notice on behalf of the respondent number for the respondent number 2. And accordingly, the registry is hereby directed to verify and put the office note accordingly in regards to service of notice on respondent number 2. List the matter accordingly immediately after vacation. We are
My lord,
listing it.
that may be fixed, my lord.
That cannot be fixed immediately after vacation.
After due vacation?
No,
after
immediately after vacation. Immediately after winter vacation.
before vacation. 34.
May I please, your lordship?
Yes.
The initial criminal revision is prepared.
No, this is for order column. Why it is in order column? Why it is in order column?
I don't
On the
know.
last occasion, none appears on call. Service is already completed here.
No. Earlier one time listed, but order was not passed.
Huh? Twice it was listed, none appeared.
None appeared.
So now you're appearing.
Yes.
Then this is you have to issue notice then.
My lordship.
Because here the case is not in the motion stage, so we are not in a position to hear the matter now. We cannot pass any order. Simple, if you want, then we can send the notice to the respondent. Otherwise, it's a case of domestic violence.
Domestic violence.
When it is fixed, next date is fixed on.
I don't know. Like that.
On the last two occasions, also the petitioner remained unrepresented, in fact. On two occasions, it was first listed on for motion, first listed on 20/03/2024, then again on 20/08/2024. In both the occasion, you remain absent. Anyway, your good name?
And Islam.
And Islam. Pardon, Mr. N. Islam, the learned counsel for the petition. This is an application. It's a revision. No?
Revision.
You have come against the order of session or principal judge?
No, I have challenged the order dated 17/9/2019.
17/9.
17/9/2019.
Passed by JMFC.
No, passed by Munship number 3. Come JMFC. Kamru Metro.
No, you have directly come before this court against the order. One interim order was there again in the DV Act. I can understand.
DV Act, another FC criminal, both the cases, interim order already granted.
No, I can understand. The both the matters. Then against the order of the learned JMFC passed in DV Act, have you applied for any appeal earlier or directly come before this court?
Directly come.
You cannot come directly. Any order against it in the DV Act, you have to approach the learned session judge with an appeal. If appeal is there and all, then only you can come before this court for revision. It seems that you have not appeared. One order is there from learned principal judge also.
Actually, my lordship, I am newly engaged in this case.
Then do one thing. We'll just issue notice then. Okay, then now what to say? Your petition is now, if you want to challenge this one or 10/7/2019, it's just very confusing, in fact. On one hand, you are saying that you're challenging the order of 17/9/2019, which was passed by the learned JMFC in connection with DV Act. Again, you cannot directly come for this court for revision. And again, on order dated 10/7/2019 also we are saying. So you are challenging 17/9 only.
Yes.
Can I argue? To say what to do.
No, DV. DV. No, it will be. With the higher disposal. Higher purpose.
against criminal revision lie hoy jana. Then this way it is not other way, because against any DV order, suppose if any grievances is there, directly appeal is there. Provision under 29 of the said act, I think, provision of appeal is there.
So
But without filing anything, he has just filed
He's
against
directly come for revision.
that too against the interlocutory.
Interlocutory order. That is also not maintained.
That is the case. Otherwise, do one thing. We're going to list the matter. Suppose after vacation, you just verify all these things. Suppose if it is in proper provision or proper forum you have filed, and it's okay as per you. But prima facie or from the face of the record, it seems that it's not maintainable, I think. So you take some time. We are listing it after vacation. See to it, and if it is maintainable and all, just come with your application. And if it is not, then immediately you withdraw this one and file fresh in a proper forum.
Yes.
Because otherwise, if it is suppose dismissed by the High Court, then it may be problematic for you to again approach it in trial court session or otherwise.
Adverse impact.
Adverse effect will be there. That's why I'm saying. So we are listing it after vacation without mentioning anything. Your name will be reflected here. Name to low level, list accordingly, and the other request, so and so list the matter after vacation. You just verify and think and just tell us. It will help you. Oh.
Okay, thanks.
Answer notice.
Yes. The steps was taken here. But the official note dated 12/11 says that the answer copy will not return because the lock door of the respondent number 2 was locked and she has been out of station for several days. But the fact of the matter is that both the parties are also participant in the proceeding before the learned trial court. And the respondent number 2 is well aware that the High Court proceeding is going on because stay has already been granted and we submitted the order of the honorable court passed by this honorable court before the learned court. So she is well aware that proceeding is going on. Even then, she has not entered appearance. So, to my understanding, that service, because they are aware, but they are not inclined to or interested in appearing before this honorable court.
So, okay, it is your submission that they are appearing there.
Yes,
okay, I can understand. But the question is that as per report, it could not be served, in fact. So, do you want any alternative mode of service? Otherwise, it's a case of
24 million.
No, 24
million.
CR case also.
CR case.
I have come against CR case. Against.
It's a CR case.
Million.
NI
Act million.
Acha, NI Act. You are the accused petitioner, no?
Yes. So far this service is concerned, it is up to your lordship. Otherwise, because that both the parties are participant, and that on receipt of the order passed by this honorable court, the proceeding before this lower court below that has been also suspended till the effective order passed by this honorable. So the parties are well aware. So to that effect, I leave it to your lordship to with regard to the service of someone's.
Obviously,
Without
service
the
to
appearance, lordship, other way also cannot be disposed of. Lordship, one other friend may take fresh steps or may wait for the service report from.
Otherwise, the other things you have taken steps to register area. I will reflect your submission here in the order. But have to take fresh steps, I think, through jurisdictional.
I'll take
through jurisdictional police station only.
Million.
And the next date is listing up next date. Next
That
date
is on 30th of December.
it is already
Yes,
been gone.
Yes.
30th of December. Itu এটা যে বলে 30 December.
30 December. Irrespective of the date, fixed before the learned lawyer court below, I shall take the steps if I am directed to do so, and accordingly, matter may be fixed.
Just I'm asking you when the date is fixed.
Because actually there are 4 cases, so that is why I'm not sure that
okay then.
Yes,
Heard Mr. A. Ali, the learned counsel for the petition. And also heard MSSH for the learned additional BP appearing on behalf of state respondent number 1. From office note dated 12/11/2024, it is seen that the notice on respondent number 2 return unserved. As with a report that the door locked and the respondent is out of station for a long time. But the learned counsel for the petitioner submitted in this regard that the respondent number 2 is well aware about the pendency of this case before this court, and the stay is also operating. Stay is operating, na?
Milord,
Stay is there,
yes,
na?
yes, Milord.
Stay is
And
also
that Milord, 7410 is the CR case number. That is on 30th of December. I've got it.
30.
Milord.
Similarly, is also operating. But in spite of the fact, she is intentionally avoiding the process. However, considering the report of the service report, let a fresh notice be issued through jurisdictional police station by the learned trial court below. No, through the jurisdictional police station, and fresh notice be issued to the respondent number 2 to jurisdictional police station. Thirty is the 30/12/50 is date field.
Yes, Milord.
Here we can fix immediately after Bihu
Milord.
vacation.
Milord.
Immediately after Bihu vacation period. Stay will be there only. Interim order be continued till next date of listing.
I'm obliged.
38.
No, please, Lord.
Services awaited here also.
Yes, Lord.
For respondent number 2.
Lordship, already a report was called for from the learned district listed Dhemaji, Lordship, regarding status of such.
Yes. A service report has been called for from the district magistrate Dhemaji by so and so. That is also awaited, I think, because there's no note. In fact, it is a note of 13/12/2024, wherein also service is still awaited. From district magistrate also, it's not received, I think. Heard your Borbhoya? Okay, sorry.
Gigi Govind.
Gigi Gogo, sorry. Heard Mr. Gigi Gogo, so and so, and also heard message for us, so and so. As per office note dated 13/12/2024, the service is awaited for respondent number 2, and which was to received from the district magistrate Dhemaji. And district magistrate Dhemaji. Let the service be awaited till next date of listing. List accordingly after vacation.
39.
May it please, Lordship. So in this case, steps were taken to the respondent. It was returned answered by remark that address left return to sender. Okay, what happened? By virtue of the order I have challenged here, that is a appellate order. Lordship, according in the appeal, the trial court order was set aside, and the trial court has started taking up the matter again. And notice was issued to my client. So what happened? The person, the accused is, the complainant is appearing in that case, but the report comes that addressless. So, Lordship, I may be allowed to serve by alternative method, Lordship, substituted manner, because otherwise, if I take steps once again by registered post, then it will the same reply will come. So I want to serve it.
Now this address
through
is,
the
the address is perfect. I mean, the address is proper here.
It should be
Bhim
because
Sen,
I have
son of
taken
late
the-
Amir Chan, resident of Jagir Road, PS Morigaon district.
The report is that addressee left.
Jagir Road is a very big area, in fact. Do you have any lane, by lane name, anything?
The case was filed by that person only, not by me. So I was not the accused in that case.
Landmark lordship.
Huh?
Nearby any landmark lordship.
Is any there? Anything is there?
Landmark.
No, that's what I'm asking.
Yes, lordship. Otherwise,
Landmark
it's difficult to locate lordship.
Because Jagir Road, if you know, the Jagir Road is a very big area, you know. So from Jagir Road, location.
Some nearby landmark, then it will be convenient.
Yes. If you have any kind of such kind of. Because you know the case is pending and he or she is appearing there.
Yes, sir. Now, he is appearing there, but I do not, I have to obtain it from that, their advocate only now, Lordship.
Yes, yeah. What is his address, in fact?
Now, second thing is that, Lordship, on the very first occasion, when the LCR was called for scanned copy, court indicated that the interim order shall be considered only after receiving the scanned
No,
copy.
interim we are not going to stay.
But Lordship, what happened, the trial court is proceeding with the matter. And if the interim order is not granted, if it is not stayed, then filing of this case in
In the first day also, if it is not there, I won't pass. I'm not inclining to pass any order.
uh,
To take steps, I can verifying the address and collecting the proper address. You can take steps through jurisdictional police station. That best that can be a
that's safe, Lordship. That step was taken.
through jurisdictional police station also.
So there is
Because
some-
AD card
Yes.
has returned back.
No, no, Lordship, there are some, I take steps by both ways, Lordship. You can kindly say. There's some report of office note. Lordship.
No, one is ordinary process, one is posted registered body. These are the two ways. You have not taken steps and it to registered, through judicial police station. Both ways mean one is ordinary and one is through registered. That is the issue.
No, Lordship, there's, I will have to see the record, Lordship. I think there's, I just forgot the term, what is written there.
Next item, madam. Eight items solved, next item.
40.
You take a record to sub office. You can see the record. You can see.
You also see. My police lordship, there is a bereavement of in the petition. Lordship, there is a bereavement in the families of the arguing counsel of the petitioner.
Okay.
Lordship, the matter.
Otherwise also, we have to await for the service because notice is not yet returned. I mean, it is answer notice is not yet received by this registry section. We have to await. So even if did any given, we will hear to it and will pass the order. No issue, no problem will be there. Okay. You are Mr.
M. Alam, Lordship.
Huh?
M. Alam.
M. Alam. Hard Mr. M. Alam. We are on 39.
40.
Sorry, 40. Hard Mr. M. Alam, the learned counsel for the petitioner. From the office note dated 10/12/2024, it is seen that the service is still awaited for response number 2. Service be awaited till next date of listing. List accordingly after being vacation.
Lordship, date may be
After
fixed.
No date can be fixed after vacation.
41. Published.
92.
Lordship, there is a section 5 application has been filed by us.
Have you taken steps for any
It is the first date today.
first date?
Notice
How many days delay?
92 days.
92 days. Opposite party is Srimati. This sole respondent.
Sole respondent.
You are Mr.
G. Kaushik.
Or Mr. G. Kaushik, learned counsel for the petitioner. This is an application under Section 5 of the Limitation Act for condoning the delay of 92 days in preferring the connected criminal revision petition against the order dated 24/4/2024 passed by the Principal Judge Family Court number 2, Kamrup M at Guwahati in FC packet of criminal case number 313 of 2020. Issue notice on the sole respondent. So and so. You need sole respondent so and so to registered AD and as usual process. List the matter accordingly. You take it step. We are listing it after vacation only. List after.
Like
For hearing 44 to 46.
Just a bit. Take it aside and you get
41.
Yes, your matter was
39.
39, yes.
Also, it was sent by usual process. It was then sent to the district magistrate of Moriga.
Lordship,
Just that's why I'm asking,
Yes, yes,
why don't you
yes.
take steps to regional election
Right.
after collecting the proper address? Proper address in a sense, if you can collect it from the council who is appearing for the her, he may help you on that regard, only for the address only. That's why. Heard Mr. R. Sharma, the learned counsel for the petition, also heard MS SH Para, the learned additional BB so and so. As per office note dated
25/9.
25/9/2024. And the answer notice in respect of respond number 2 has been received back with a postal remark, address left RTS. In that context, but the service from the district magistrate Morikau is still awaited. In that context, the petitioner is hereby asked to take fresh steps through jurisdictional police station after collecting the proper address, if any. Let the matter be listed accordingly after vacation. You try this one, Evan.
May I serve a copy to the guest counsel in the court below on the next day?
Council, that is not permissible, in fact, right?
Otherwise, justice
Other,
service is not permissible.
because justice service is not here. Probably you can talk, you can serve a notice, I don't know,
I said-
but in
Yes,
the
sir.
order, I should not reflect this one,
Yes.
that's.
I shall file a petition in the court below from which you will also get the knowledge.
Okay.
You can- Yes, yes.
44 to 46.
Oh, 44 to 46. These are, I mean, you are for in both the, huh? No.
Appellant accused.
Accused appellant in 3 matters only.
3 men.
I mean, there are,
Between same parties.
between same parties.
Yes.
So there are 3
3
cases were there.
3 cases where they were convicted by the trial court.
But I just want to tell one thing. It's only the 3:30. In fact, I'll be on leave.
It will take some time also, Lordship.
And that apart, I'll be on leave also. So judgment may not be delivered immediately. That
Lordship,
is,
we may start argument if it's all right. If it's all right, we can start the arguments. Judgment can be
we
given.
cannot keep it in part heard.
Correct.
Part heard will be again difficult on your part only because it, I don't know, my bench will be there because the roster will be there changed. And again, that apart, I'll be on leave on entire February month. So that may be one of the difficult, if it part heard, remain part heard.
Let it be fixed.
Is there any stay is there, I think?
Stay
Stay
is there
there
since
already.
2019.
2019?
Yes.
2009.
Oh. Since 2019 only.
Approximately 1 lakh rupees in all the 3 cases are due. If they could like at least deposit some amount as per 148, then also we would be all right with the adjournment.
No,
I'm not
148,
taking
prayer
action.
for 148 was not there before the appellate, the learned code below.
No.
After amendment, it is 143 is after amendment, so that at that moment we had not submitted any, deposited any amount.
It was not there.
Not there. So that
Okay,
we did not deposit.
Okay. Now at this stage, it's not the case also. and so.
At the hearing stage, so that
Matter may be part heard, but it will again remain as part heard.
that is what.
That is one of the aspects. Otherwise, but from her submission, it is seen as stage operating since 2019. It's quite.
That is why Lordship for final
The
hearing.
proceedings and the trial
Any date
court,
may be fixed for final hearing.
the
Otherwise,
No, it's hearing only, final hearing only.
yes, Lordship.
Lordship, the trial
Oh,
began in
hearing.
2010. In
Yeah.
2016, trial court held that they were